We should be ready to start now. Honorable members, I think we are now collating and we should be ready to start our meeting. Can we check if there aren't any members that are still outside? And also just warn honorable members beforehand that this meeting actually is on camera, so we should guard against having a lot of food in front of us, because otherwise people are going to lose hope that this land will ever come back to them. Say, honorable members are having a good time here. So they have arrived, so the struggle has actually been abandoned. Honorable members, greetings once again. I welcome the Honorable Minister and thank him for actually making time to be here today. This is an extremely important meeting for us, and also welcome to the acting DG and your team. And honorable members, welcome. I will hand over to our secretary to actually read out the apologies, if any. Thank you.
Thank you, Chair. Good morning, members. Good morning to the Minister, and good morning to officials and everyone present. We have an apology from the Deputy Minister. He's absent because of illness. And we have an apology from Honorable Madikizela and Honorable Madlala. And Chair, the Minister requests to leave before the end of the meeting because he had some commitments. Thank you, Chair.
Thank you, Acting Secretary of this committee. We have a longish program of this meeting, which was actually circulated to all honorable members. I just want to present it for adoption by this meeting. It's a longish agenda, but it is we can actually do justice to it if we actually conserve time. Is there any proposal for the adoption of this agenda? Honorable Adams.
Sorry, morning, Chairperson, and good morning to all in the room. I move for the adoption of this agenda. I thank you.
Thank you, Honorable Adams. Any seconder? Honorable Wetama, do you have your? Or Honorable Na?
Don't tempt him, Chairperson. Good morning, Chairman, and good morning, everyone. I move, I second for the adoption of the agenda.
Thank you. Well, as you can see, we will actually be having the the remarks from the Honorable Minister, and then after which then we will get a report from the acting DG. Then we also want to welcome Professor Levin, who is actually also with us, and also Mr. Mbenze from the Legal Aid South Africa, and both of whom will actually be making presentations. And we have also some civil society people, the Association for Rural Advancement, AFRA, and the Farm Dweller Labour Tenants Alliance of South Africa. I hope they are here. And also we are expecting some input from Dr. Ngubane from the Nelson Mandela University. Then after which we'll actually have discussions, questions for clarity, and also some comments. Then we'll have a lunch break at hopefully at 1:30, and then after which then we'll continue with questions and answers. Then at 2:30 we will then be dealing with organized agriculture, getting their perspectives to labor tenants issues. Then followed by, during that, we will have Agri-SA, represented by Mr. Janse Rabi, and we also have AFASA, Mr. Mtombeni and Mr. Mutepu will also be here. Then followed by questions and answer, and then after that we would have our closing remarks. So, without any further ado, I think I just want to say this before we actually, as a precursor to our own meeting, that approximately 5 years ago, in 2019, the Constitutional Court confirmed the 2016 Order of the Land Claims Court, which actually declared that the Department of Agriculture, Land Reform and Rural Development, which now is Land Reform and Rural Development, has failed to process labor tenant applications, and that this was inconsistent with the Constitution of the Republic of South Africa. A key interest point of the portfolio committees is an appointment of a special master for labor tenants to supervise, monitor, and oversee the department in an implementation plan for settlement of labor tenant applications. So there is an important debate to be had about the supervisory, monitoring, and oversight role of the court vis-à-vis the oversight functions of Parliament. Today's discussion, whilst it may reflect on this issue, is concerned with the speed of settlement of labor tenant applications and stakeholders' perspectives around what should be done to accelerate the delivery of land for labor tenants and secure their tenure. We have invited stakeholders who will present perspectives from the executive authority, the courts, legal services, organized agriculture, and other civil society perspectives, as I had actually outlined here in our program. Of great importance is the lived experience of labor tenants by their representatives. The order of the proceedings, as I have actually presented, I don't want to repeat that. So it is our intention that the stakeholder engagement process will be documented in a report that will be tabled in the National Assembly for a debate on these issues. So I will now hand over to the Minister for brief remarks, and then the delegated officials from the Department of Land Reform and Rural Development. I thank you. Honorable Minister, over to you.
Thank you, Honorable Chairperson, and greetings to you, Chairperson, honorable members of the committee, Professor Levin, in his capacity as the Special Master, Acting DG, and officials of the department, invited guests. Thank you for convening this engagement, Chairperson. It reflects the seriousness with which this committee treats the Labour Tenants program and the broader constitutional obligation to secure tenure for those who have remained on land without legal certainty for far too long. We meet today in the shadow of a constitutional court judgment that found this department wanting. The Mwelase ruling expressed clear findings on the institutional failure. The Constitutional Court held that government had not processed claims as required by law. That judgment changed how the program is managed. It placed the department under court supervision with the appointment of a special master to oversee the implementation. We do not dispute the court's findings. The facts were clear. The implementation of the Labour Tenants Act had stalled. Some of the delays were structural, others were avoidable. Since the judgment, the department has taken steps to reset the program, align with the implementation plan approved by the court, and rebuild systems to allow progress to occur in a more structured, transparent, and accountable manner. Our presentation today does not seek to defend the indefensible. It is a realistic accounting of progress and limitation. Over 20,000 claims were submitted before the deadline in 2001. We can confirm that more than 11,000 have been finalized. Just over 9,000 remain unresolved. The delays, especially in high-density provinces like Mpumalanga and KwaZulu-Natal, speak to resistance on the ground and gaps in institutional capability. The Special Master's quarterly reporting framework has created greater visibility. We've begun to shift from fragmented response to a system based on data, procedure, and consistent referral mechanisms. Yet we are not where we should be. Too many district offices operate with limited staff. Some provinces lack any dedicated unit to Labour tenant work. Court referrals remain slow. Finality remains elusive. We have included budget trends, human resource allocations, legal referral numbers, and operational metrics. All data are disaggregated by provinces. We do not believe this committee is served by generic information. You'll find specific figures for each performance year, alongside MTF projections to 2029. We are clear on the task ahead. We are governed by an existing law and binding judgment. Our duty is to execute with care and with urgency. Chairperson, I now invite the Acting DG, Mr. Clinton Heyman, to lead the presentation on behalf of the department. He is supported by DALRAT program managers who have worked closely with the Office of the Special Master. If you allow me, Honorable Chair, hand over to the Acting DG.
Acting DG, you have the floor, please.
Thank you, Chairperson, honourable members of the committee, Professor Levine, and colleagues across government. Thank you, Minister. I want to thank you for the opportunity to open this briefing session on the Labour Tenants Programme. The session provides a critical opportunity to reaffirm our legal obligations to reflect on progress and to ensure that the path forward remains aligned to both the Constitutional Court's directives and the Department's institutional accountability to Parliament. In the venue today, we have with us the DDG for Land Redistribution and Tenure Reform, Mr. Ndove, the Chief Director responsible for Labour Tenants, Mr. Zulu, Chief Director Zulu. We also have the Chief Land Claims Commissioner. We also have the DDG Corporate Services, Mr. Lupongela, and we also have the Chief Director, Ms. Frances McMenamin. The presentation to follow, Chair, will be structured in a direct response to the committee's request. DDG Ndove and Zulu will lead this presentation. It's technical in nature. However, I would like to frame my engagement by first clarifying 4 essential positions in the department: the legal mandate, the operational interface on the implementation plan with the special master, our procedural integrity that we require for any proposed changes, and the systematic risks that we must guard against as a department as we move forward. When we look at the constitutional mandate, I think the Minister has alluded to the case between the department, the Director General, and the Molase case, and it was concluded then that the department lacked institutional capacity to fulfill its obligations. The department and the Special Master have jointly submitted in 2020 a agreed-upon implementation plan, and the plan was approved by court and remains the binding framework. Currently, Chair and committee members, we are in our 5th year of implementation, and also the final year of that implementation plan. I think it's critical to emphasize at this point that the court did not transfer the implementation authority to the Office of the Special Master. The Special Master is an officer of court, and at this stage also not the executing agency. The department therefore retains the statutory obligation to deliver, while the Special Master's mandate is supervisory to facilitate operating under the court's oversight. As we move forward into the next 5-year term that has been called for by the court, the department will work closely with the Special Master in revising a new implementation plan, and we welcome any innovations that the Special Master would suggest in such a plan. I think the most important thing for us is that as we extend the plan, we need to ensure that we capacitate the department and the officials in that plan, because at some point the Special Master may not be there, and then we need to ask ourselves the question: how are the 180 land tenure officials or the 18 specific contract officials, how are they going to better manage the system? Because we can train everybody else in the country on how to deal with Labour tenant matters. However, if we don't capacitate the staff members, we will lose that capacity forever. Even if we look at the current structure, we are currently working with our HR department to get the contract positions extended for a longer period to at least align to that of the Special Master, so that we don't have a constant changing implementation arm. And those are really the areas that, if you see the presentation by Mr. Zulu now, that we will focus on going forward, and we look forward to more detailed engagement with the Special Master on this. I'm not going to go into further. I think I can go on for much too long. I think that I would now like to hand over to DDG Ndove, and Mr. Zulu specifically will take us through the detailed presentation. I thank you, Chair, and I thank you, members.
Thank you very much, Honourable Chair and Honourable Members, the Minister, the Deputy Minister in his absentia, Acting DG, and the Professor Lavin and the colleagues. I'm going to go into details in terms of the introductory remarks by the Minister and the Acting DG, and I will focus on the on the areas that the portfolio committee asked us to focus on. There are 4 areas which I'm going to deal with. The reflection on the achievements and challenges, the reference to the court order and the implementation plan that was developed. I think the minister and the acting DG have touched on it. The overview on the staff complements that are in the provinces that are implementing this program, and also the budget allocation and expenditure on the program for the settlement of these programs on the 5-year. We've broken it down per province, and the projections on the MTEF, the medium-term expenditure framework. Historically, in terms of the background, as we understand that the system of Labour tenancy was extensively practiced in the main 3 administrative areas or 4 provinces of the former Union of South Africa, the Orange Free State, Natal, and Transvaal, which is now Natal is the KwaZulu-Natal, and then Transvaal, it covers those provinces like your Mpumalanga, your Gauteng, your Limpopo, and parts of Northern Cape, of Northwest. But the system, if you look at our figures and the data that we have that we will present today, it excludes especially the Western Cape, which was the Cape Colony, with a little bit of some pockets of Labour tenant applications in the provinces like Eastern Cape and Northern Cape. We don't have a lot of them. However, specifically in the Western Cape, there was a different system that was used. It was not necessarily the Labour tenancy system, although it was abolished, but the system, the structure remained, and those Labour tenants, although those persons remain as tenants in those particular areas. In terms of the Labour tenancy, these persons or communities were only given the right to residence, grazing, cropping and growing the crops, and also getting food rations as for their labor instead of a wage. But they remained after the abolishment of the system in 1964. They also remained as tenants on these farms or these commercial farming areas or privately owned farms. In terms of the legislative, the response from the government to give effect to Section 25(6), to deal with this particular challenge in commercial farming areas and privately owned land, 2 pieces of legislations were passed. The one is the Land Reform Labour Tenants Act, which we are dealing with today, Act 3 of 1996, and secondly, the extension of Security of Tenure Act 62 of 1997, as amended, which has since been amended. And this particular or specific legislation, the Land Reform Labour Tenants Act, it seeks to provide security of tenure to these labour tenants as the applicants, after receiving the applications, to provide security of tenure to those persons occupying or using land as a result of their association with the labour tenants. It's not necessarily the labour tenant itself, and also provide that security of tenure to persons occupying because of their association with the labour tenant, and also provide for the award of land or acquisition of land and rights in land by labour tenants, what is important, with the assistance of the state. So therefore, it means the labour tenant claim is lodged against the state as a particular as an important stakeholder in the process. I've put the definition of the labour tenants because it's very important in the Act, because that is where we define the labour tenant. That is the gist of our referrals when we refer the matters to court in cases where land orders are resistant or they denied their status of these labour tenants. There is case law also that has been passed. The courts have ruled on this particular matter around the labor tenancy where there is the rejection by the landowners. They define it as persons who are residing and have the right to reside on the farm. And secondly, persons who has a right to use cropping or grazing land on the farm, which is referred to in under A, or another farm of the owner, not necessarily that farm, and in consideration of such right provides or has provided labor to the owner or a lessee or a person in charge. And thirdly, the person whose parent or grandparents resided or resides on a farm and had the use of cropping or grazing land on such farm or another farm of the owner, and in consideration of such right provided or provides labor to the owner or lessee of such other farm, including, lastly, a person who has been appointed as a successor to a labor tenant in accordance with the provisions of the Section 3, subsection 4 and 5 of the Act, but excluding a farm worker. That is the definition as contained in the Act.
I'm sorry to interject. I just want to warn the presenter that actually he has 10 minutes to actually do the presentation. So you can proceed, but bear that in mind.
Okay. Thanks, Honorable Chair. There are two ways to cycle the labor tenants as lodged in terms of Section 16. Is settlement by agreement between parties, and secondly is referral to court. We have indicated that the DG is responsible for referring these matters to court in terms of the Act. The Act always puts an obligation to the DG to refer the matters to court in cases where the labor tenant has admitted that the applicant is a labor tenant, and then there are specific timelines in terms of by when the proposal must be submitted to the DG in terms of settling that labor tenant application. The resolution of these claims, as I've indicated, we received the section assistance in terms of the Act that these persons lodged these applications on or before the 31st of March 2001, which the Minister has indicated the numbers. I will talk to those numbers in brief. I'm not going to go through the circumstances in which the labor tenants, but in the main is an award of land or the rights of those labor tenants as contained in the Act. In terms of Section 17, we are obliged by the Act to, in terms of the initial procedure, to notify the landowner or a person in charge or the lessee of the land in terms of the application that we have received from the applicants, and then we have to publish that in the Gazette within a specific period of time, as indicated in the Act, the 30 days. Once the admission, if we admit, the Director General also puts an obligation to the Director General, and within a specific period referred to in subsection 4, to if the landowner, if he admits that the applicant is a labor tenant, the Director General shall either party request for either the matter to be referred to court if there is a disagreement. The certification is in terms of 18.5 of the Constitution. Obviously, that puts an obligation to the DG to certify if it's satisfied that the proposal is reasonable and equitable. However, that has since been delegated to the Deputy Director General. And the main part that, because of the resistance, as Minister has indicated, that has delayed, attributed to the delay in the finalization of the labor tenants, is the court referrals, because most of the applications, the landowners, they've resisted, they've denied them the status of the labor tenants, and the DG has no option but to refer that matter to court in terms of Section 18.7A and subsection B. In terms of land acquisition, then once if there is an agreement, the minister has the power to grant subsidies for the acquisition of that land to finalize the Labour Tenant application. And that has since been delegated to the DDG to administratively. And also the minister has got the obligation, also empowers the minister to release subsidies for former Labour tenants, if they were associates, to acquire to be awarded the land. They've alluded to the court order, which was very specific in terms of dealing with the outstanding Labour tenant claims. I think I'm not going to repeat that, which were lodged in terms of Section 16, 17, and 18. Section 18 talks mainly to the resolution of the Labour tenant claims that have been, applications that have been received. I'm not going to talk to the role of the special master. They've dealt with it. However, the order was very specific. The implementation plan was very specific in terms of the areas, the elements of the order of the implementation plan, as the acting DG has alluded to, which in the main included the targets as well. These are the statistics, as I've indicated. The minister have alluded to them. We have over 9,000 that are still remaining in terms of our records. In terms of what we have done, we have embarked on a process with the court to deal with the legacy cases that are pending in court, which were referred to court since 2013. We've done an audit of them. We still have outstanding matters that we still have to audit. However, the court have asked us to put on hold the process while they're analyzing the outcome of the cases that are pending in court. You will realize that the numbers, if you look at the numbers that are pending in court that have referred to court because they were denied, they're quite massive, from 2013 to 2024 to 2022. And we are still referring some of the cases to court. Then once they're referred to court, the department or DG does not have control over the court processes. That is where we have, the minister has indicated that there is a slight delay in the finalizing those. We are continuing in 2023-24. We've referred to 2024-25 to date. We have referred to over 308 cases to court. That function of referring the matters to court was delegated from the DG to the directors in provinces administratively in order to fast track the referral of these matters which are denied. This is an extract from the cases that, from the presentation that was done by Legal Aid to this particular committee, which indicated the cases that are still pending for legal representation. The 498, the Legal Aid is here, we'll talk to it. In terms of the performance, we have provided the performance against the targets in the operational plan. As indicated, as I've said, the performance does not look good with those factors that I've indicated in terms of how the factors that attributes to the low, the poor performance on the targets. And then this financial year was only 34% performance. If you mesh the implementation plan targets, which in our view was a little bit ambitious, looking at the realities on the ground and the court referrals, you will see that there is a discrepancy between the numbers. What is sitting in the current implementation plan, the 5-year plan, as the acting DG have indicated, which we will need to review because it has reached its 5th year, and what has been finalized and what was sitting in the operational plan. Obviously, the operational plan took into consideration the capacity and the limitations that we have indicated. This is the budget allocation, as I've indicated, as requested by the portfolio committee, and you will see the decline in terms of the budget allocation year after year from 2019-2020 to 24-25. The MTF allocations, as we requested. We have provided that in terms of the allocation. The capacity issues at a national level, we are responsible for all the land reform, the land tenure reform programs and the implementation of all the 9 pieces of legislation. In my office is myself and the secretary, level 7. We have level 13 to 14, we only have 5 persons, officials. Unfortunately, the one that is very important, which is the National Program Manager, is on a contract for Labour Tenants. Unfortunately for now, she is a one-man show in the department. What is vacant, out of the 4 directorates, there are 2 that are vacant. In the provincial level, the breakdown, we have got 180. The committee, I want to indicate that the 180 officials that you see there are the officials that are not only responsible for the implementation of the Labour Tenants. They are responsible for all the programs as indicated there under the land tenure reform program as a whole. And we have noted that we have under level 13 the directors, there are 9. However, 8 are filled. 1 is vacant for some time in the Northern Cape. Level 11 and below to 12, we have got 24 that are filled out of 39. 14 is vacant. Level 10 below, 123 filled is 95. 28 is vacant. However, what has happened is that the only Mpumalanga has the 18 contract posts which are only dedicated towards the implementation of the Labour Tenants. Unfortunately, the contract is only 12 months, which I think as a department we need to look into that for continuity. These are just the challenges. I'm not going to dwell much on them. I've alluded to most of them. And in this slide as well, I've cited some examples in the cases that we're dealing with in Mpumalanga, which the portfolio committee is aware of, which we visited together with the portfolio committee, the Nkambule case, the Kanyile case in Kleinfontein Farm, etc., etc. Thank you very much, Honorable Chair and the members.
Thank you. Back to the DG.
Thank you, Chairperson. That then concludes the presentation.
Okay.
Thank you.
Thank you. Where are we now? Then we call Professor Ngubane, Richard Levin. Well, the next one would be Professor Levin. Honourable members, the Minister had actually indicated to me before the start of the meeting that he would actually like to be excused because there is a pressing matter that he needs to attend to just right now. I think he actually reported that there is serious sickness in his family. In fact, his wife is actually been admitted right now. Yeah, I just hope that he will be able to come back, and we wish your wife actually speedy recovery. We will keep her in our prayers. Thank you, Honourable Minister. I just hope that you will find your team still in one piece after you had left. Over to you, Prof.
Good morning, Honourable Chairperson, honourable members, colleagues from the department, colleagues from civil society, all protocols observed. My colleague from legal aid. Thank you very much. Yeah, I think, you know, a lot has been said, and I'm also going to say a lot from our perspective. And perhaps it's important to say that this judgment is very complex. It can't be reduced to some of the formulations I've heard over here because of the depth and unusualness of this judgment. There's no judgment like this that ever happened in this country before. Yeah, there's no judgment that ever happened in this country before this. It's absolutely unique. There is no sector or area of work where the courts basically made a determination. And essentially they made that determination in terms of Section 38 and Section 172 of the Constitution, where they did say that a remedial action is required, an unusual remedial action is required, which will override the normal powers. So if we, because the first part of my presentation is very much going to focus on, you know, a bit of an unpacking of that judgment, because it's important that we do this. And that, in a sense, has been a major obstacle to progress. The fact that, you know, we have no consensus on what the powers and the functions of the Special Master are. And that repeatedly creates delays, even where we make agreements on interventions which are administrative, which need to be implemented, then we have delays which follow. So we somehow need to get over and beyond this and to accept the unusualness of the judgment and to implement this program in the spirit of what the judgment really means. Because we're not going to make progress. We will see that we try to make certain interventions around strengthening the court referrals. We reached agreement, we had thought, but then ultimately the department went to take advice from the state attorney, and the state attorney rebuffed them and said, go and work. The judgment is very, very clear on the role and functions of the Special Master. So we're not going to solve that here, but we need to somehow get beyond it. Because to say that the department is constitutionally responsible for the implementation of the program, and then to say there's supervision, oversight in one sentence doesn't actually make sense. But power is not really the issue. The issue is Labour tenants. Labour tenants are the ones who are on the rough end of the stick here. And that is where the focus must be. The focus must be on providing relief for Labour tenants. And to get away from this endless debate about who is in charge, who is in control, if we can just focus on this program and what this program is intended to do, and that is in the objects of the Act. The department is always responsible for the objects of the Act. Any single act of Parliament is the responsibility of a minister and the department. They have to take ownership of it. So yes, it's true that the court process puts the department in a different kind of position as a respondent. The claim is made against the landowner, by the way, not against the department. The department is responsible for securing the land which the court awards. So this is a complex judgment. It can't just be described in a few phrases the way it has. So if we just look at some of the highlights of it, you know, what we can say is firstly that the judgment affirms that the three branches of the state, that is the legislature, the judiciary, and the executive must work together to secure constitutional promises to the most vulnerable. Now, that's the important thing about this judgment, is that Labour tenants are part of the most vulnerable groups of this society, and there is a constitutional promise that is made to them in terms of Section 25. And in the case of them fitting the bill, as it were, or the definition of a Labour tenant as described by Mr. Zulu, that is the constitutional promise, that they will receive secure tenure on land. Okay, and that is really the role and function of the department, is to ensure that that is secured. Not simply to kind of follow an administrative process which says if we fill in Form 6 of the Land Claims Court and submit it in an empty file, we have complied, and that's up to the court now. And then we'll show tables and tables of how the court has not processed the claim submitted to it. So that is those are the things we need to unpack in detail. That's under the leadership of the judge. Because essentially it's not under my leadership. I'm an extension of the court. That is what is in the Constitutional Court judgment. I'm an extension of the court. I'm not the power itself. The power is in the court. I'm the agent of the court, exercising its supervisory powers over the department. Now, these distinctions are very, very important to understand. But let's say another key part of this is that where a rights infringement is extreme, the Constitution requires the courts to impose remedial action, including supervised oversight of administration, should a court deem this to be what is required. And that is what the Land Claims Court deemed was required, and that is what ultimately the Constitutional Court upheld. So that is the role, power, and functions of the special master. Is it supervised oversight of administration? You know, if you look in this whole court case, blow by blow, when it went to the Supreme Court of Appeal, Mr. Quinty made a lot of promises in terms of capacity. And he brought in his agent, who was Mr. Mdonswa. He was brought in to administer this program in lieu of a special master, and ultimately they won this case on that basis. But then the applicants decide to continue to the Constitutional Court, which reinstated the application in its fullness and confirmed the role of the special master. So the courts deemed it necessary to intervene on an evidence basis to correct erroneous interpretations of the law or to protect rights infringed. So to say that we are a party in court and we have no responsibility over Labour tenants is a misinterpretation of law, because Labour tenants, according to the Act which the department and the minister administer, Labour tenants have a right, and that's the right that has to be protected, and that's the right which the institutional incapacity of the department led to being infringed. So that's really how this court judgment unfolded. And there's been too much interpretation of the role of the special master in terms of the court order that followed it. The court order that followed about the issues raised mainly by Mr. Zulu relating to the application and resolution of the application process is in that particular order. Firstly, it deals with the appointment of the special master, the process to be followed. The applicants had to bring forward a candidate, which happened to be me, and the department did confirm that, and the court then confirmed that. So that's really how this process took place. But those first steps in terms of the application processes and so on is not the judgment and its interpretation in entirety. I don't really think we're going to resolve that in this meeting here, but I thought it's important to say that the judgment is more complicated and complex. So what is this failure to fulfill constitutional obligations that the Constitutional Court was referring to in its judgment? It is that the department failed to process labour tenant claims as required by law. So those 11,000 claims, the majority of them, over 9,000, according to the evidence led by the Director General at the time in court, those were resolved using other land reform programs and mechanisms, including land redistribution and land restitution. So I have not had a mandate, nor have I tried to secure a mandate to review what's done. We are trying to focus on where we are now, the way forward, and how to make sure that the outstanding claims are processed as required by law. But the Constitutional Court did go further, because it said the failure to resolve the labour tenants in terms of the law violated constitutional rights and duties. And that means that the court explicitly found the department's inaction unconstitutional. So that decision to use the other programs and to by and large bypass the court was ultimately rejected by the court. Those dormant cases that Mr. Zulu showed in the slide there, yes, that is all true. There are dormant cases, but most of those were filed in terms of Section 33(2)A of the Labour Tenant Act. That allows anyone to approach the court. You don't even have to have your matter referred by the DG. But the precedent set in declaring people labour tenants in terms of 33(2)A was that no award of land was made. So what did I say in the beginning? We need to start with the people, and we need to start with the land. Who are the people, and what is the land that they are pleading for in court terms? And that is what is critical. So if we simply fill in Form 5 and we submit it to court, Form 5 or Form 6 of the Land Claims Court, and submit it to court, we're not going to get an award in land, because there's nothing which is telling us about the land, unless Mr. Mbense is now willing to go and measure the land. And this thing must be project managed, DG. It has to be project managed. So if we're planning, even on a mediation, to resolve matters, then the labour tenants are in a very unequal position in a mediation process if they are not armed with their rights and a depiction of their rights. So the work we've been doing with the National Geospatial Institute actually empowers labour tenants. Because of the mapping processes we follow, which are participatory in nature, the labour tenants get to own the map. They understand the map. They can talk to the map. They own that map. Now, why would we not want that to happen, where we have all the capabilities in the department, whether it's in the SG offices, the NGI, or in Spluma, to empower labour tenants to enter a mediation process on an even playing field? So I think, you know, that's the point I'm trying to make in relation to where the judgment lies. So the breakdown required a systemic remedy, a remedy of systems. And much of what I'll be saying after going over the judgment is to say that we have applied our minds to creating systems. There's never been a database. We've created a data system with the department, with the cooperation of the department. This thing was ready end of 2021, and it only got approved at the end of 2024. So it's the issue of the delays. That is the struggle one is having. Why, even when we agree on something, does it take so long before we have action? It's true. The situation on the staffing is appalling. And if we count those global numbers, as Mr. Zulu pointed out, they don't point to the real issue, and that is most of the tenure staff are working on other matters. And most of the tenure staff working on labour tenant matters are also working on CPAs, which consumes most of their time, trying to manage and put remedies into CPAs that have become dysfunctional. So what is this role of the special master then? It is court supervised support. It's not executive usurpation, because that's the other point. We're not taking over the role of the executive. We don't pretend to do that. And we operate within the supervision of the court. So the aim is to strengthen rather than usurp executive function. Our aim is to make the department shine. That's always been our aim. When the department shines, we shine. When people put the special master in a corner, I can't just point to the department, because I'm supposed to be the major partner of the department and the co-creator of the solution. And that's really what we are trying to do and what we are trying to achieve. But my problem is, even when we reach agreement on interventions and steps to be taken, the time lag is just far too long. So I want to now get on to the issue of some of the things we've done. Like I said, we built a Labour tenant claims resolution system with the Office of the Chief Information Officer in the department. It was completed in 2021, but the system was never rolled out. Only approval from the EXCO came in October of 2024, and it's still not implemented. So we need to implement. We've created a portal for Labour tenants as well, but it needs to go hand in glove with this Labour tenant claims resolution system. So any Labour tenant using a Nokia phone or a smartphone or whatever can send an SMS to the department and get a response, which will indicate where the claim stands. So those facilities have been created. But we really need to get this data system up and running, and then we can even use the portal to update the data system, because we can have a campaign which will get Labour tenants sending in their particulars, and if necessary, make corrections to the existing particulars which are there on file. So we have a fully functional resolution system. It's ready for deployment, but it remains dormant. And these are the things we're appealing to do, is let's just speed up. Let's get these things up and running and working. So what we tried to do at some point, which I've referred to already, is we tried to introduce an interim practice note. And this was when the state attorney, because many of the referrals were first going to the state attorney in that period when we arrived. And the state attorney was not really dealing with them. And we can have the debate, but I know Mr. Mbense has made it clear to me that that's not the state attorney's role, and it never has been. But whatever the situation is, we've had court referrals piling up in places. So the state attorney contacted my office. There was a seconded official from the department in my office. He attended the meeting with the legal officer from Mpumalanga, and the state attorney was saying there's no content in these files. We can't really process them. So we then said, okay, let's put in place an interim practice note. But the interim practice note was giving a role of quality assurance to the special master. And ultimately, that quality assurance role became embedded in the standard operating procedures. And I don't know if that is the sticking point. But the quality assurance role is essential, and the court can always give me the quality assurance role on the other side of things. But I prefer that we work together on these things and get them perfect by the time they go to court, rather than me being called in by the court to then review the applications. And the sole purpose of all of this was to strengthen the quality of the referral. And right now we're in a situation where a whole number of referrals are going to be returned by the judge, because I was called to the court a few weeks back and informed that we now have to comply not only with the Labour Tenant Act, but the Land Court Act. Any matter that appears before the Land Court Act must demonstrate that it's been through a process of mediation. And if we're going to demonstrate that it's been through a process of mediation, like I've said, somehow the Labour tenants need to be empowered in that process of mediation. The landowner will have a map. The landowner will have a survey sketch diagram. And if the Labour tenant goes into that mediation without those facilities, then they're going to be lost. They're going to be lost. But if they have a map that they understand and they can interpret and are bound by it and dedicated to it, then obviously the mediation becomes a different story. So the whole mediation process, given its importance, needs to be reviewed, in my view, because at the moment the department appoints a neutral mediator. That's fine. That's its role. But in a mediation process, remember, the landowner will be on the phone, on the cell phone all the time to his lawyer, and the Labour tenant won't have access to legal representation as compromises are put on the table and suggested, etc., etc. So we must make sure that there is a balance in the mediation. Okay, we also introduced a methodology which we benchmarked internationally, and we speak in the implementation plan about mass claims resolution. And really we need the judgments which will set precedents about land, about the issue of fencing people in, about the issue of impoundment of cattle, about all those issues. And that's why any court referral, any basic research, any land rights inquiry made by the department must not simply say, this is the applicant. It must say, this is the, because we saw the definition. It's 3 generations. This is the applicant, Petros Zwane. This is the parent, Mandlinkosi Zwane. And this is the great-grandfather or great-grandparent. And it's actually gender neutral, so it can be a female applicant as well. It doesn't have to be a male applicant. So that must be contained in any referral. That's basic oral history inquiry. It will tell us about, because we revised the questionnaire with the department, with legal aid. We use the legal aid instrument for the introductory engagement with Labour tenants when they sign them up. And we came with a new modified questionnaire which does all of this in a straightforward, basic way. Any person who's a project officer in a district office should be able to implement this. We're there, we're ready to train, we're willing to roll out, we're willing to support in all the steps. And then the geospatial investigation. Because the basic determination of a court is, yes, this is a Labour tenant, or these are Labour tenants. This is the area of land that they have claimed, that they are pleading for. So if we do this land using proper surveyors in a process which fully engages the Labour tenants, then I think we're moving in the direction of just and equitable resolution of Labour tenant claims. We also reviewed and updated the department's standard operating procedures. Largely, we left what was there intact. We didn't reinvent the wheel which was already turning. We just mainly changed the land rights inquiry, as I've said, to make sure that we are able to give the area of land, the extent of land being claimed, as well as to show that the Labour tenant, in terms of the 3 generations, qualifies to be a Labour tenant. So one of the issues that happened with the claims lodgement process, which came up repeatedly in the court, was that many applications had been lost. In fact, in legal terms, it's common cause that applications were lost. So the department did outsource to NGOs, a consortium of NGOs, the lodgement of the claims. It's an imperfect process. It happened long ago, so there's no point in harping on about the failures, but it's just about asserting the fact that many claims were lost, and we need to therefore have a process which will recognize that, and the court is likely to sympathize if we are able to put sufficient facts together and have an affidavit which accompanies it. So we developed the lost claim strategy with the department. And it has raised the hope of many Labour tenants, but we need to roll it out. We need to say, okay, so what are we going to do proactively to ensure that people's whose claims were lost are going to be considered in the resolution of claims on a particular farm or a particular area. We also, in the implementation plan, agreed that we would have some kind of a pilot, which is known as the Multi-Site Accelerated Claims Resolution Initiative. So there's about 30 farms which have been selected. with just under 600 applicants. And then there's other complaints that have reached us, which are not necessarily part of the MACRE, but they are matters that are being worked on by the department. So sometimes the department brings these to us as well. It's not even the way we cooperate in different provinces. I can say that in Mpumalanga, Gauteng, Northwest, Northern Cape, we've had excellent cooperation. Yes, and Mpumalanga is really prejudiced because they don't have staff. Because what we don't say is every time a contract elapses, it takes another 6 months to renew it. So you'll have no one in office. Then they'll come in, they have to be re-equipped, they have to be sort of oriented. This time in the midst of a major change of a departmental split, it's not easy, and I do have sympathies with the department about managing all these challenges. It's better to acknowledge them, in my view, than to deny them, because people are, in a way, getting frustrated by the length of time of things that are happening. So we have tried to resolve the lack of pace. We did create a compliance register, which looks at all the orders and directives from the court and even agreements we make amongst ourselves. And we've run it a few times. It's been resisted quite strenuously, saying the methodology is not clear. We have submitted how this works. It's a basic auditing method. Each action where a time frame is agreed, the length of additional time taken, you begin to count as the days of non-compliance. So it means it's cumulative. Even if things are running simultaneously on different directives or different orders, it means that you add them cumulatively. And that's why we last did it in 2024. We ran it, and we found that 18 years had been lost. So this is a challenge. We also have a governance structure that we agreed upon. We presented to court, and then I have signed it, but the DG has not yet signed it. So we don't know why. Maybe we can have an explanation, not necessarily here, but we can actually deal with that so that all of us are on the same page, committed to the same issues. So this slide just explains what I did explain now about the cumulative procedural delays. And we have a solution, though, as well, to dealing with the management of the program. It's in the implementation plan. It's called a war room. It's a program management forum. We need to come together. So we came together in the beginning. That, for example, led to the cooperation with the Chief Information Officer and the creation of the Labour Tenant Claims Resolution System. But there are other areas, particularly to go on a quarterly basis, project by project, which is in the plan, and say, what is holding it up? Where is the blockage? How can we jointly work to unblocking the blockage, to speed up a process, to get things done? So anyway, we have agreement that we're going to prioritize that with the department. We hope to host the next war room, towards the end of this month. So I think that is also going to help us to overcome the challenges. So this table is the same one as Mr. Zulu put up. We see and we note the reduction in targets. The only thing I would say is if we're going to reduce or amend targets, given the role that I've defined, and yes, there's a dispute about the definition of the role, why is it that we are reducing targets without at least telling the special master, we suggest that we reduce the targets? Why don't we just have an open discussion about how to manage targets? And the best way, by the way, is through the war room, because we'll develop a practice. And then we're going to begin to see how long things, different steps in the standard operating procedure takes. And then over time, we'll be able to plan much more rigorously and meet targets and track particular problems, unblock them, and move forward. So really, I am asking.
Sorry,
I'm not
Prof.
here
Prof.
Yes,
to
I'm
interject
concluding.
you. Oh, thank you.
I'm concluding. I'm not asking to, for anyone here to condemn the department. I'm just talking the truth. If I come to Parliament as an agent of the court, I'm compelled to talk the truth. That's what I am compelled to talk. But what I am really appealing to is that we come together like we have with the National Geospatial Information Office, with Mpumalanga, Gauteng, Northern Cape, Northwest, and show enthusiasm and commitment. And we look at the Specials Master's mandate as an opportunity, as a national vanguard. I don't have the same work that Mr. Ndove has in terms of the spread of responsibility. I'm just focusing on one sub-program. Even Mr. Zulu's got a much broader mandate than I have. I'm not there to fight the department. I'm there to make sure that the rights of Labour tenants are upheld and managed through court legal processes to bring relief to this group of highly vulnerable South Africans. So the Constitutional Court was clear. The failure to process the applications violates fundamental rights. We've come with systems, with methods, with reforms. They developed, they tested through the Macri, they're ready. So let's implement. Let's implement. Let's not argue over who's implementing. Special Master is one person with a tiny office. Obviously, we can't implement. The department must implement. That's what I agreed with the previous minister, that we'll work with the capacity of the department to implement it. So that's really what we just need to focus on. And then obviously deal with the issues and the challenges brought by court in terms of the institutional dysfunction and other blockage that imperil the rights of Labour tenants at a systemic level. So the toolbox is there. The solution box is there. I'm saying let's join hands. Let's join hands. Asibambisene vele. Ayikho enye indlela ngaphandle ukuthi sibambisane nje senze umsebenzi wethu sonke. That's the only thing I can say. Thank you very much for the opportunity.
Thanks, Prof. Well said. It's very clear. Yeah. Well, at this juncture, I would actually request the legal aid South Africa to actually make their presentation. Hayi ngiyakuzwa Prof, uyalo impela, ngiyakuzwa. I can hear.
Good morning, Honorable Chairperson. Good morning, honorable members. Good morning, colleagues. We have prepared a presentation. In terms of our outline, we'll take the committee through the legal aid SA mandate. Legal aid SA mandate overview, Labour tenants' rights, appointment of a special master and recommendation, provisions of legal services to Labour tenants, finalized Labour tenants matters, and also reflections on recent Labour tenant cases that have been before the court. We'll also take the committee through implications for the processing of future land tenure applications and parliamentary oversight. We'll also take through the committee. Which is the issue of labor tenants' rights. My colleagues have touched on this issue of Section 25(6). Actually, there are 3 legislations that were promulgated as a result of Section 25(6). Labor tenant is one of them. IPILRA, which is IPILRA, it's Interim Protection of Informal Land Rights Act, as well as ESTA. There's Section 16 of LTA that allowed labor tenants to apply to the Director General to recognize their rights in land they occupy. So they had to make that application before the cutoff date, and the cutoff date was 31 March 2001. So it is impossible to state the exact number of applications lodged before the cutoff date, because some of the applications were misplaced by the department, as the Special Master indicated, and the department as well. However, in different sources and documents, it is estimated that 20,000 applications for right in land were lodged by labor tenants before that cutoff date. Unfortunately, not all applications have been processed, and therefore the rights envisaged in Section 25(6) are not being sufficiently protected. If there's a dispute about whether a person is a labor tenant or not, the matter must be referred to an arbitrator or to the land court. If the court determines that the applicant who applied for acquisition of land is a labor tenant, it must then proceed to determine what award to make to the applicant. And that includes an award of ownership of land or servitudes to either the labor tenant or the owner, or compensation to the labor tenant instead of an award of rights in land. As explained, the Land Reform Labor Tenants Act targets labor tenants, some of most vulnerable people in South Africa. This is the issue that the Special Master has mentioned with regard to, for more than a decade, the department neglected labor tenants in favor of other land reform programs. So we mentioned programs like restitution, plus proactive land acquisition strategy and others. So as a result of the department's action, thousands of labor tenants were languishing in limbo until labor tenants brought the application to compel the Director General. So the purpose of the application was designed to set that wrong to right. I'm going to proceed to the appointment of a Special Master. The Special Master was appointed to ensure the proper and speedy implementation of rights of labor tenants relating to application for acquisition of land. That is the purpose of the appointment of a Special Master. And also what is important as well, so when labor tenants were in court, they sought an order, the supervisory order directing the department to formulate and file a plan for processing labor tenants and provide regular reports as well. The Special Master assisted the department to develop implementation plan. Professor Levine has touched on that the implementation plan was developed with his assistance. The Special Master assists the department to certain functions as envisaged in Section 25(6) of the Constitution and Section 16 of the LTA. We've got recommendation there. Our recommendation is that the Special Master must focus on supervising the implementation of the plan that had already been developed to ensure that all labor tenants' claims are successfully processed and finalized. And also for the Office of the Special Master to sufficiently perform its function, so it must be provided with sufficient resources. This is Section 25. We are also saying that the Section 25 of the Constitution is to provide security of tenure as well, or comparable redress. That is important as well to people whose security of tenure is insecure as a result of past racially discriminatory laws. That one is important as well. It should be taken into account that the purpose is to assist those that were suffered as a result of the laws of the past. However, the purpose intended by Section 25 has not been fully realized, in that the rights of farm occupiers and labor tenants are still being infringed by the farm owners in different ways. We are just mentioning the common infringements there, like the eviction without following the procedures specified in legislations. We are also mentioning the denial of burial rights. We are also mentioning the livestock impoundment, reduction of grazing camps, denial of rights to renovate houses, and also access to basic services. Those are common infringements. I'm going to talk to the issue of provision of legal services to labor tenants. As legal aid, we inherited 218 matters involving the interpretation of LTA from the department. However, Legal Aid South Africa has received 358 new labor tenants matters since taking over, which is 2022 to 2025. And the bulk of the matters, as appearing there, were recorded by us at Legal Aid in 2024 and 2024-2025 financial year. This slide reflects the new matters that were received by us at Legal Aid. We are just dividing them into provinces. And the new labor tenants matters were received in KZN, followed by Mpumalanga province. Here we are talking about the new matters. We are just separating them per local office of legal aid. Because of time, I'm not going to take you through this slide. We are talking about finalized labor tenants matters here. Since taking over the land mandate, Legal Aid South Africa finalized 141 matters. As follows, we are just breaking them down into financial years here. Okay, out of 141 resolved matters, 4 matters were unsuccessful after the trial, 42 were successful after the trial and through ADR, and 95 of those matters are matters in which legal aid was terminated for various reasons. I mentioned client deceased, passed away, lack of instructions, lack of prospect of success after merit assessment. We are also talking to the issue of clients terminated legal aid mandate. This slide reflects the finalized matters per province. I'm not going to go through it because of time. This one we are just separating it per local office. Even this one. Okay, this is important. Reflections on recent labor tenants cases that have been before the court. The department is referring a high number of labor tenants matters to the land court, and legal aid is prioritizing the filing of the statements of claim in response to notice of referrals. Last week alone, I think we received, because I checked with our manager, we received about 20 referrals from the department last week. Implications for processing of future land tenure applications and parliament oversight. Any future processing of land tenure applications will have a significant impact on the capacity of Legal Aid South Africa, as we currently do not have sufficient capacity to deal with land-related matters. I'm going to mention the categories where we need resources. Legal Aid SA require additional funding to cover the cost for experts, like agricultural experts, property valuers, and land surveyors, etc., as the most labor tenants matters require expert evidence. It is proposed that Legal Aid South Africa and Special Master may be requested to table at the Portfolio Committee on the land rights quarterly progress reports on land-related matters. I'm just coming to policy or legislative implications and challenges. Here we are just pointing out the challenges in legislations, but we are also saying that we want to make recommendations as well, because we can't only point out the problems without making recommendations as well. The first challenge that is mentioned there are labor tenants who did not lodge claims before the cutoff date of 31 March 2001 and were thus excluded. And moreover, some claims were also lodged, were also lost by the department. So our recommendation, we are saying that claimants should have the chance to relodge the application So what we are motivating that the Act should be amended just to extend that date of 31 March 2001. So Labour tenants must be allowed to lodge applications again. And also Section 3 of LTA, you are saying that when read with Section 16(1)(a) of the LTA, entitles Labour tenant or his or her successor to apply for an award of land which he or she was entitled to use or to occupy or use on 2 June 1995. That date as well, it causes some of the problems. We are also saying that we're requesting Parliament to amend legislation as well. An amendment to Section 3 to allow Labour tenants or his or her successor to apply for an award of land which he or she was entitled to occupy or use before that date. So we request Parliament as well to amend the legislation. There's also another problem as well. The word forthwith under Section 17(2)(a) of LTA. So that word unduly empowers landowners to challenge the Director General for failure to issue Section 17 notices immediately after receiving Section 16 applications from Labour tenants. We know that in some of the matters, the Director General has not issued Section 17, and the landowners are relying on that to say that the word forthwith, so the Director General is supposed to issue Section 17 immediately after receiving Section 16 applications. So we also request an amendment there. We are saying that an amendment to Section 17(2)(a) by removing the word forthwith to avoid challenge from the landowners. And also, we are also saying that Section 19 of LTA empowers the judge of the land court to direct either the application to be heard by court or to be referred to the arbitration. However, we know very well that there's no panel of arbitrators. So our recommendation is that there should be there should be an appointment of arbitrators. So the duty lies with the Department of Land Reform and Rural Development, as well as our the Minister of Justice as well. Section 23(1) of LTA entitles the owner of the affected land to just and equitable compensation as prescribed by the Constitution for the acquisition. We are also saying that an amendment is proposed to this section to make it clear that in some circumstances, just and equitable compensation can be zero. And we are also saying that the Minister of Land Reform, in consultation with the Minister of Justice, is empowered by Section 31 of LTA to compile a panel of attorneys. I have already touched on that. We are talking to the issue of overlapping claims for LTA and restitution as well. This is important as well because in some of the farms we find that there are claims that are overlapping. So our recommendation is that the Department and the Commission of Restitution of Land Rights must identify the overlapping claims and develop a strategy of handling overlapping claims. That is our proposal. And also we are talking to the issue of the department's failure to transfer land to Labour tenants. Here we are talking about matters, the land that were transferred before Mwela's judgment in terms of that proactive land acquisition strategy. So those farms were transferred to the department. They were not transferred to Labour tenant. So those farms must be transferred from the department now to Labour tenants. We are also talking about the land court not sufficiently capacitated. Our recommendation is that the land court should be provided with sufficient capacity in the form of additional judges and support staff. And also, we are identifying the lack of funds also as the problem to conduct public awareness on security of tenure. Funding should be made available to ensure outreach on educating Labour tenants on their security of tenure. This is the implication of the Land Court Act coming into operation. So with the additional mandate expected when all sections of the Land Court come into operation, Legal Aid will require the following 21 additional High Court legal practitioners to cover the following provinces. We are just mentioning the provinces there and also the resources that you require. Okay. Moreover, there will also be recurring operational expenditure such as printing, stationery, and all of that. So we also request Parliament as well assist us with regard to that, the additional resources to cover all of that, the laptops and all of that. With the additional mandate expected when all sections of Land Court Act come into operation, Legal Aid SA will require additional budget of 23 million per financial year in order to fulfill its mandate under the Land Court Act. Thank you so much. That is the conclusion.
Thank you, Honour the Legal Aid. In terms of our agenda, we are supposed to be breaking for tea, but because we actually have lost a great deal of time, I'm going to ask that we do not break for tea. We go straight to questions and answers from honourable members. We're trying to catch up with the lost time. Honourable members, it's over to you. And our questions will actually be focused on the presentations that so far have been made. Thank you, honourable members. I will recognize hands. Can we switch off that mic? The mic next to you, DG. I recognize the hand of Honorable Mklitama and Honorable Matiase, Honorable Dr. Mahlatse, Honorable Nana, in that particular order. Starting off with Honorable Mklitama.
Thanks, Chair, and Professor Levine, and also the other members from the department and honorable members.
To adjust your mic.
Okay.
Let's see.
Yeah. Maybe that's better. Okay. Thanks again, Chair. You know, Chair, this matter of labor tenants, just like other farm workers, is a very frustrating matter. We are sitting at 30 years since the commitment to deal with the rights of labor tenants was communicated in terms of the law. And in that 30 years, we see we are just over 50% resolution stage. So we're going to need another 30 years to resolve these labor tenants cases. I see no possibility of addressing these labor tenants matters in a reasonable time. Even your suggestion from the comrade from Legal Aid about opening the claims process. We're going to sit with the same process that we have with restitution, where we have not resolved the old order rights and new claims are parked, and there is no movement. The problem of labor tenants, of course, is because there are rights involved. We have heard just now that even now, burial rights, the right to be buried. So you are a labor tenant, you are landless alive, you are landless in death. The power of white farmers derive from the fact that they have land, and our people are landless, and that is why they are so vulnerable to these human rights abuses. So our failure to address this matter is licensing the continuation of abuse of farm dwellers and labor tenants. So I'm just frustrated by this lack of progress. You know, Professor Levine, the bureaucratic inertia and the complexities of implementations are kinds of talks that I don't think we are interested in. We're interested in when are these claims going to be resolved. That's all. Those challenges that relates to the complexities of definitional questions of different responsibilities and even lack of support are matters that we expect the department and the special master to resolve internally. Tina, here we are not interested to hear what those challenges are. We're interested to know when are these outstanding labor tenants claims going to be resolved. Me and you, Comrade Levine, we know the problem of Fubabu Kambule, who is a typical example of the problems that besets labor tenants' problem. Babu Kambule is under constant attack by the racist farmers, precisely because he has put a claim, and as soon as you put a claim, you're antagonizing the other fellows. Now they are trying to constructively remove him out of constant harassment. And failure to provide land for Babu Kambule means that you are prolonging his suffering. So, Chair, I really don't know what must happen, except that we obviously need to ramp up the targets. Also, I mean, really, we can't plan to fail. So the question is, by when can we say realistically these claims will be resolved? By when? Can we have some kind of a clear statement to say, all matters considered, this is the time which is going to be required, and the resources as well, which are going to be required to resolve these claims? Because we must talk about the resolution now of these claims. The numbers that are set for targets are way too low to resolve the outstanding claims. So we need to have a realistic planning process. Given the amount of outstanding claims, what is required to resolve these claims in a reasonable time? We can't think for another 30 years. All of us will be dead by then, including the labor tenants themselves. So we are working for a different generation when we are not going to be there. Can we resolve these claims in our lifetimes? And that is going to require very clear statements about how many claims can we resolve by what time. And of course, the resources which are necessary. Then we can engage Treasury. We know there's always a problem of money. But to be able to say, here's the bill which must be paid to resolve these outstanding claims. Now we're talking and lobbying on the basis of a concrete numbers which correlates to the challenge that we are seeing. We are failing our people, and the longer we stay, the longer we making sure that there's abuses of our people on farms. And we are complicit by our failure, all of us, because all of us have a role to play. Failing to resolve this matter, it means we are complicit in the continuation of abuses of our people under these racist, violent white farmers. They are, and they are also resisting. So I'm interested to know what mechanism do we have, in fact, when these people resist, besides taking them to court? Because when they resist to negotiate, then we must take them to court. Then we have the backlog that we have there. Maybe we need to be creative about whether we have another way to compel them to accept. Once a farm dweller is defined as a farm, as a labor tenant, then we must be able to enforce those rights. But as things stand, Chair, I'm not seeing any real progress here. Enkosi.
Thank you, Honorable Glitama, for your input. Honorable Matias.
Well, thank you so much, Honorable Chair. Honorable Glitama should not include me when he says we are part of the problem.
But he said all of us.
I'm saying he must not include me. No, dying, of course I will die, but it must not include me in his categorization of people responsible for the crisis we are sitting with. My father was a farm laborer.
So was mine.
In Afrikaans, they would say is plus arbeider. So there was a system called plus arbeider stelsel, farm labor system, that confined him to work as a farm laborer. He died in 2007. He would have been about 78, 77, 78 if he was alive. So I'm not part of the problem of the gentleman sitting over there. So I should not be counted amongst those who are part of this problem. There's nothing the department presented here that makes sense. There is no, let alone political will, which is absent. And there is an interface between the politicians who are appointed as ministers and officials who are appointed in the department. There's a close interface, a political interface. So if politicians lack political will, officials must have an administrative and legal will to show politicians how to do it. And when they come before the portfolio committee and say, we have tried our best, we have shown them the administrative, legal, institutional way to do it, they couldn't do it because they lack political will and commitment. We can excuse officials for having done their part, but insofar as things stand, they have not done anything. There's no institutional capacity. There is no political, administrative, financial will to resolve these problems. So what is the point of having these gentlemen and ladies here? No, if the problem was lack of political will by politicians, and all of them, of course, without exception, lacks that will, we would excuse the gentlemen and the ladies for having at least done something administratively. The court has rightly decided, or wrongly, to have Professor Levy to supervise officials. He's an activist on the ground. He's there with the volunteers. He's there with the landlords, with these labor tenants. He tries to suggest systems, policy, institutional mechanism to resolve these problems. But all of this fall on deaf ears, on men and women who are oblivious of the plight of farm labor tenants. Completely oblivious. So what is the point of having these gentlemen to come and through the minister's leadership? Perhaps we can excuse the minister because he's only 12 months in office. What is the point of having these gentlemen and ladies to come and present something which is really nothing, Honorable Chair? We have questions there which we can put to the legal aid, to the special master, which questions are but an academic exercise which will take us nowhere. Perhaps we need to remove all the officials and say and speak directly to Professor Levy and say, let's do it. What do you need? Put together a team that will help us get this thing done in the next 12 months. What resources you have? If you don't have resources, let the committee assign resources. If the 9 million that has been allocated for 2025-2026, Honorable Chair.
9 billion.
9 billion is what Professor Levy needs. Let's allocate that 9 billion to him now. We have referred several cases, and this is my last point, to legal aid. Through the minister's office, Minister Nkwinti, Minister Didiza, on labor tenants who are victims, who continue to be victimized across the country. We meet with them. They write to us, they send SMSs and WhatsApps. Honorable Mketama refers to the matter of Mr. Nkambule in Khair Siband. In the most notorious area of Piet Retief. Donker is what?
And Wakkerstrom.
Wakkerstrom. To this very day, Honorable Chair, and perhaps this follows on you and me, we haven't done anything despite numerous repeated discussions in this portfolio committee calling on your good self to meet with your counterpart in the police and everywhere else in the justice to get into that space and ensure that we come to Mr. Nkambule's rescue. Even such meetings that are possible between ourselves and our portfolio committee counterparts, such meetings haven't happened. This one falls on you and me, and we cannot blame it on the gentlemen and the ladies on the other side, who clearly have got no capacity whatsoever. So lastly, Honorable Chair, without even entertaining the gentleman from the department, I think I propose that they must be dismissed from this engagement. They are of no value, they are of no use whatsoever. We listen to the other stakeholders, AFRA and other stakeholders, to propose solutions. And at the end of this session, us and them and Professor Levy come up with concrete practical solutions to these problems and determine timeframes and recommend resources that must be allocated and assigned to Professor Levy, and then says, out of this exercise, something concrete has emerged. I'm a socialist, and socialists are practical individuals and believe in practical solutions. Not this endless, idle conversation and talks we're having here. We've been having this idle conversation and talks for far too long, Honorable Chair. Action needs to be taken. Thank you so much.
Thank you, Honorable Matias. I agree wholeheartedly that action needs to be taken, but I'm not sure about actually dismissing the officials here, because even the concrete proposals that we might come up with Professor Levine and the rest of the civil society organizations would need to be implemented at some stage by the same officials who have not actually implemented anything, as far as you have actually said. It's a vicious cycle that will actually bring us back to where we actually are right now. I appreciate that you actually have a very direct and pointed, kind of contribution where the problem lies, and then we need to actually come up with a solution. It's a pity that the minister is not here to listen to the cries of our people out there, because we must come up with a workable implementation program because it's really useless to sit like this and talk and talk and talk, because next week and next month we will still be talking without any tangible results from what we are actually talking about here. Honorable Dr. Mahlatse.
Thank you, Chairperson. Thank you to the department. I have a few questions here. Okay, just a general question to the special master. In 2023, the SMLT, working with other stakeholders, introduced the concept of the broad-based funding for settlement of Labour Tenants application. Is it the same as Labour Tenant Rights Affirmation Fund? Please explain this concept. Is there any buy-in from the National Treasury or other government and non-government stakeholders? Second one, please explain the useful of MACRI and the Labour Tenant Implementation Plan. Has the department cooperated with this plan? If no, why is it so? What are the powers of the SMLT when there is no cooperation? The question to the legal aid. The recommendation that the special master must focus on supervision of the implementation of the plan give an impression that the special master might have deviated into implementation of the plan or otherwise. Do you think that the special master has in the past focused on implementation of the plan rather than supervision, monitoring, and oversight? The second question, if yes, what has the department been doing? Now, the court has directed the special master to supervise and monitor the department's performance in settling Labour Tenants' claim. 3 questions. How will the department characterize its working relationship with the special master over the past 5 years? Second question. Given the oversight visit report on Gambule family and the others, has the department consistently implemented agreed action with the SMLT? My last question. Has court supervision improved the performance? If so, how? If not, what challenges remained, and what does the department propose to accelerate the land delivery to Labour tenants? Chairperson, I submit.
Thank you, Honorable Honorable Mahlatse. Honorable Nana.
Well, Chairman, you can close the question session. You know, those questions were from a doctor. He's not a doctor for nothing. You can, I mean, he pretty much took out words off my mouth. You can allow the department and everyone else to respond. But you know, now that at least you have recognized me, I'll have to say one or two things. Chair, on a serious note, you know, colleagues will recall that ever since we turned back the delegation from KZN and the Eastern Cape for lack of preparations and for lack of adequate preparations, the committee has been very clear and literally portfolio committee meeting one after the other since then. We have been expressing our displeasure to the minister, to the deputy minister, to the then acting DG, we have been expressing our displeasure at the attitude, at the I don't care attitude, or business as usual attitude by officials of this department. Literally, each and every meeting, members have been raising this concern. And I do know at some point we also had our closed meeting to talk about it. It can be that every time we get to meet the department, there is clear indications of laxity. There is clear indication of not taking one's work serious. And I do know we've had a discussion as the committee about this. My request is that we need to put in motion the decisions we made as quickly as possible if we are to arrest this situation. I know it doesn't happen often too well to agree with Honorable Matthias, but I really do want to second the majority of what he has submitted this morning. It's completely unacceptable. Professor Levine says it will take up to 6 months to fill up a post, a critical post. I was once a technocrat in my life, and I don't for a minute think that I was top crop bureaucrat. But at least things like advanced planning, it's something that as a bureaucrat you have got to live and breathe. How do you wait until somebody's contract expires, acting DG? I know you're new. How do you wait until somebody's contract expires and then you start scratching your head, thinking, you know what, let's advertise this position, having known from the day you hired the person that the duration of this person's contract is this much, and the duration of your recruitment process as the department is this much? Why is it so difficult, acting DG, to be proactive, try and plug those holes? If my contract is expiring in December and your recruitment process it takes 4 to 5 months, for God's sake, why don't you start advertising 6 months before to try and make Professor Levine's work easy? It is unacceptable. And I would really want to get an explanation from the department. Why would you guys allow such a thing to happen? I see that DDG for Corporate Services is not here. To the legal aid, if my memory serves me well, you are not appearing before this committee for the first time. And a question was raised in our previous engagements about your ability to undertake this new extra work. I got a sense from your response, you will remind me. I got a sense that we are pretty confident that you can carry the load. I was suspicious. I wasn't comfortable, but I took your word. And now I'm not surprised that you have got budgetary constraints, you've got issues with expertise. But here we are. What is the plan? What are you guys planning to do about it? Are you planning to ditch the mandate and say you can't continue, or well, I mean, what's the plan? Two issues. The one that I picked up from your presentation is lack of instructions. And you said some of your clients will pull out halfway through, if I understood you correctly. Do you guys conduct exit interviews with your clients, whether you have completed the matter or not? Because I do think those interviews can actually shed light into what your clients and would-be clients are thinking about you and your performance. I can imagine when you take up a matter for client A, you prepare all the paperwork, the documentation, you go to court for a first appearance, it gets postponed, that's cost. You come for the second appearance, you make your presentations. In the middle of that, the client pulls out. Legal aid has incurred costs. Are your clients made aware that there is cost involved? They can't pull out as and when they wish. At least somebody has got to have tangible reasons to do so. Otherwise, this can go down as fruitless and wasteful expenditure. Property valuers, Chairman, we have an OVG in-house. You don't need to come to this committee and lament legal aid that some of the expertise that you lack are property valuers, for instance. This department has got OVG, Office of the Valuer General. I'm sure if you can engage them, they will gladly consider that. So I'm trying to say, please, some of the expertise that you spoke about, I do appreciate the fact that, in the course of your work, you will need those expertise. But if you guys don't have, please look elsewhere amongst government before you go and get somebody who will charge us a lot of money. And lastly, Chairman, on my side, there is an important proposal made by the legal aid, that of amending the Act to allow Labour tenants who couldn't lodge their claims after 2001. Please, can we really flag that and get it as a point of discussion, probably as the committee? I wouldn't want us to lose sight of that proposal. Thank you, Chairman.
Honorable Nana. Honorable Nyambo, you have just walked in. I'm not too sure whether, or Honorable Adams, I'm not too sure whether you have anything to actually say by way of comment or question, because you have actually been disadvantaged in the fact that you were not there when presentations were made, but nonetheless you received their submissions beforehand, and I guess you were able to go through them. So don't be shy to raise your hand if you feel there are issues that you want to raise. For now, I will actually allow Honorable Adams to make a presentation or to ask a question or make a comment.
Thank you very much, Chairperson. And good morning once again to the officials of the department and everybody in the room. Chairperson, I will go straight to my questions. My questions will be about labor tenants. On page 16 of the presentation reflects outstanding claims per province. The Gauteng, KwaZulu-Natal, Limpopo, and Mpumalanga provinces contain figures, but the variance between large and financial claims is quite concerning, which results in a high cumulative number of outstanding claims totaling 9,034. What accounts for this high number of outstanding claims? On page 17, shows audit of legacy labor tenant cases pending in court. However, the last audit was conducted in 2017 and nothing since then till the date yet a number of cases were filed. What is a reasonable explanation for this lapse of time? And on page 18, there is a provincial breakdown of referral of cases to the Land Claims Court, amounting of 308 cases for the 24-25 financial year. What is the turnaround time for the court in setting claims? And my last one on this part, in terms of legal representative, a total of 1,407 matters are referred to the legal aid. What is the experience in processing such matters? And then, Chair, on the questions to the Special Master, let me just get my questions there. To the Special Master, in your reports to court, it appears that there are cases where you do more than supervision, monitoring, and oversight work on behalf of the court. If it is so, why do you end up developing strategies and working on research and other important labor tenants? And then the second question, has that approach helped in terms of the existing relationship with the department officials? I note that in the presentation there are many instances where the department has not fully cooperated with the SMLT. My last one on this, Chairperson. In 2023, the SMLT, working with other stakeholders, introduced the concept of broad-based funding for settlement of labor tenants applications. Is it the same of the Labour Tenants Right Affirmation Fund? Please explain this concept. Is there a buy-in from National Treasury or other government and non-government stakeholders? Chairperson, I wanted to continue with the whole presentations, so I'll go over to Dalrit presentation, slide 15. On the budget transparency, what is the actual allocation for labor tenants claims in 2025 and 26? And then how many claims will resolve with that allocation? And my last question on this part, has the department implemented the labor tenant implementation plan effectively? What is the access and what impediment remain? And then on slide 16, outstanding claims. Why is performance poor in provinces like Eastern Cape, Northern Cape, Free State with only a 7% and Limpopo 1%? Are provincial officers cooperating? What support or intervention is needed? And then slide 19. The 498 cases are noted, but lack a timeline on referral Labour court cases. Can the department provide any analysis of these cases, and that what progress has been made in older cases? And slide 20 on annual performance trends. Why has performance remained so low over the 5-year period? And what led the increase from 10% in 2023 and 2024 to 34% in 2024-2025? And what lessons can be learned from this? I'm almost done, Chair. Slide 21, performance indicators under hectares acquired. What legislative framework were used for land acquisition for ESTA occupiers? How many hectares are linked specifically to the 91 settled Labour tenants? And then slide 22 on down adjustment of targets. What period does this adjustment cover? Has the court approved this deviation? If not, how is the department justifying non-compliance with a court sen? Slide 23, budget underspending, Chairperson. With coverage expenditure at 45%, it lack of funding the real constraint. If not, what are the main causes of persistent underspending performance? My last one, Chair, on slide 26 and 27, human resource capacity. Free State and Northern Cape have staff, but little to no performance. Why? Why is there such low delivery in Limpopo, Eastern Cape and Free State, despite having staff capacity? I thank you, Chair.
Thank you, Honorable Adams. I think it was during the presentation of Legal Aid South Africa, if I'm not mistaken, where a mention was made that there are some applications which were lost by the department, and also a suggestion being made that those the owners of those applications should be allowed to reapply. Maybe one would need to understand these lost applications. How is it possible that in a department people can make applications and then they disappear? I would personally like to to have that unpacked. And from me, the last one would be a reiteration of the question or a comment made by one of the honorable members that the department really would need to explain to us how they characterize its working relationship with the special master over the past 5 years. Because, I mean, from listening to Professor Levin, I could only hear a lot of frustration, which actually emanate from the fact of lack of cooperation in a number of fronts. So, you know, the unpacking of their relationship is very paramount for me. Yeah, thank you. Honorable Nyambose and Honorable Boshoff, Vele Itse. Oh, thank you.
Thanks. Thanks, Chair. Pardon me for arriving in the latest of the hour. I'm perfecting my speech as well for tomorrow. I thought I have a holiday for today, but it's okay. I had looked at this. We have coined a very nice institution, Special Master of Labour Tenant. And we make it look so fancy when the act of labor, it was actually slavery by the white farmers. And there is something painful which is missing here. We get to hear about labor tenants. We never get to hear about the perpetrators of the acts that are done on this labor in this farm, to the point that we get one side of the story. In law, we say, hear the other side of the story as well, audi alterem partem. But we are able to bring labor here. We never get to see these white farmers who commit some of these crimes. And they get away with murder. Why? Because our legal system.
Sorry, Honorable Nyambose. Agri South Africa is actually one of the organized farmers associations or organization that is going to make a presentation today here.
Okay.
Thank you.
Which is good. No, thanks for letting me. But I want to also drill in there that they are able to hide behind Agri-SA to come and speak for the farmers, as if Agri-SA condones their action. I'm looking for an accountability of an individual farmer, like in the case of Danny Dalton. That farmer drives over Abantwana, 3 children, and he labels them as dogs. This is a South African farmer, which we must respect. So I hope in Agri-SA, in coming to account, will take responsibility. And what is even worse is that there is no accountability. In fact, I can tell you here what has happened. I think the mayor of that area took some of these farmers who said they will pay 2,000 rand to the family to contribute to appease them for having killed these children. This is what has happened on this case. Now, this is the nature of the environment the labor tenants they find themselves in. Yesterday, I thought was a perfect meeting where one of the honorable members said, how did we stoop so low to talk about labor tenants and we never get to talk about landlords? And landlord is regarded as these white farmers. But I know for a fact they are not, but there is another institution which we have relegated in the institutional arrangement. So it legitimizes that white farmers are legitimate, and it says Amakosi are illegitimate because we define them outside the legislation and the constitution by not giving them their jurisdictional rights, because I can contest that space where those white farmers are sitting on. But that gets never told. We focus on labor, which labor they are abusing, and now we even have a special arrangement for their matters to be heard. But as we hear these matters, the conclusion is always not in favor of these people. What the chair has just said is exactly the case in point. In KwaZulu-Natal, in Nomondin to be specific, and in Edumbe, you have these arrogant white farmers who have the captains of the police stations in their pockets. As you go and report a case in the police station, the very culprit white farmer is standing with the station commander. And then you don't get joy. Why? That's where the dockers get lost. They get lost because they talk their way. Then this is another thing they do. They have their private security companies that are monitoring the space wherein they're obstructing the SAPS role and space of doing policing, where they bring their own sake kamer security forces who are also protecting their farms. And these guys, they continue to do this thing. In the case of Edumbe, it didn't end by that white farmer saying that those families are bringing illegitimate cattle. Now they experience a death. In that death, he still continues to stop them from having a ceremony to bury their loved one. Police are not responsive. Government is not responsive because you've given Section 25, which says protection of the property of the minority. And then you live outside the majority, which is 22 million population, which resides in that space. These are the dynamics which I wonder how is it helping us to always hear these matters, but we are hearing one side of the story. These culprits, they continue, and they have money, so they use money. Our legal system is subtended by money. If you don't have money, you can't sustain a matter in court. No wonder those who are victims, they are on the receiving end of justice because they cannot sustain any matter. If you want to continue, legal aid cannot always sustain your matter, even if you've got merits of the case. So I'm saying, as we view these matters, I would like us to bring the centrality of saying, we were never tenants of white people. We were landlords. Today, that is no longer the case. And we will address this matter. But in this case, I wouldn't even discuss this because this is an organized syndicate of white farmers who kill our people to no avail. Kill our people, no law enforcement agencies that respond. So, which means when people take the law into their hands, it is because we know them, we see them. I have cases where police station is working with them. No wonder then there is no progress on this matter.
Thank you.
Thank you.
Thank you, Honorable Nyambose. You've actually made your point. Can I hand over to the acting DG and his team?
Thank you, Chair. And thank you for all the presentations. To the Special Master, your presentation is honest, to the point. And I think firstly I need to say, rightly so, and this is no excuse, that joining newly as the acting DG, I still take full accountability for the presentation. I do also say, as we answer the questions, that we will move forward and work with the recommendations not only of Portfolio Committee, but also of the Special Master. We are not adverse to using technology, driving innovation. In fact, it is my team, that's the geospatial team, that's busy. When I say my team, I'm talking about when I'm in spatial planning and land use management, that are assisting with the building of the system. The ICT systems I will prioritize. I undertake to work closely, at least in the next 2 weeks, with the Special Master, get behind the issues. I think I just want to say sometimes it's, and I still support the statements I made from the team and the work that's being done. However, from here on in, for the while that I'm acting, you're welcome to address the issues to myself and Special Master, yourself also, and we will get to the bottom of the ways we can improve the system. I do think maybe one of the comments is, what is the relationship between the Special Master and the department? And I think here we have to find that outreach, that olive branch to say, we've been doing this for 5 years. We have to find a common cause with the court and the department. We acknowledge the gaps in the HR systems. I have Mr. Lupongela here with the DDG Corporate Services. We will deal with those contracts that are outstanding and try and get them fast-tracked. So, I can't make excuses. I can only try and fix the problem as we go forward. my undertaking here to the committee and to the Labour Tenants is that we drive the process as hard as we can to fix these things. I know the Minister has met with the Special Master this morning, Prof. Levine, and he has made undertakings that we will urgently meet with him, with the senior management of the department, and this becomes a priority. I'm sure I wasn't in the meeting, but I'm sure there are other commitments made by the Minister. We will honour those, and we will then now start with the questions, and there are a number of them. The team, I think, will start with, only rightfully so, with DDG Ndove, and we will work through the questions in a succinct fashion, please. Thanks, DDG.
Thank you so much, Acting DG. And greetings to the Chair, Honorable members, the Prof. Levine and the other stakeholders that are here today. I'll share the work with Mr. Zulu. I'll try to deal with issues that I feel I'll be able to express myself better on them, and the others I'll give them to Mr. Zulu. Unless there are other outstanding, then I'll come back. Maybe let's start from what you have just said, Acting DG. There's a difference in terms of contracts. There are contracts for, which is when the Special Master was appointed, he has to get a team to assist him to do his work. And that was decided by court as well, besides appointment of the Special Master. So those contracts, as I indicated, they've been renewed and they're all geared up for the next 5 years. But the contract that they are referring to, so I just wanted to separate so that we don't, the ones that we're referring to are the ones in the department, not for the team that works with the Special Master, but the acting DDG will also talk to that. But I just need to also indicate that the Mpumalanga issue must also be looked at also with the KZN issue, because at a particular point they were in a similar situation, but we have managed to create posts that were contract into permanent posts in KZN. What we have not done up to so far is the one in Mpumalanga. So I just wanted to indicate that it's not like nothing has been happening. The other challenge that we had is the issue of changes that have been happening to the extent that not only the Labour tenants that are affected in terms of matters that relate to appointment, the whole department has not been appointing anything in the last, let me say, 18 months or so. I think the Mr. Pungela will yeah. So I'm just saying that it is not a deliberate assault or ignoring the work of the Labour tenant. It's just there have been challenges to the extent that things are even beyond the department as we speak. There's been a commitment that until we had what we all know, talking about fit-for-purpose structure, that will actually make this post become permanent. I'm talking about the Mpumalanga post. This challenge remains with the department, and it's up to us to manage to make sure that there are contracts that are being initiated. It is true that in some other cases there were lapses in between, which is regrettable, but it's something that we will be able to manage until we make sure that these posts are actually covered. I thought I should clear that, Acting DG, so that when Mr. Pungela comes in, he will talk about what is the way forward, going forward, in terms of making sure that the human resource is made available all the time, and recruitment is done timelessly, responding also to what Honorable Nana has indicated. Honorable Mgutama, you spoke about when are we going to complete. Actually, you're talking about a plan that is realistic going forward in terms of resolving the outstanding claims. We have already indicated that there was a plan that was developed together ourselves with the special master, and that is the plan that is still existing as we speak, and is the plan that needs to be properly evaluated. Of course, if we look at the numbers are not good. But as to where are the key areas that needs to be tweaked or changed as we move on to because we're now moving to the next term of another 5 years. Obviously, this plan will not work. So I'm saying that there is an opportunity in that regard to develop a plan that is realistic, and I like the word realistic, because the ambition on this plan that we have was that we will have completed the 8,000, 9,000 claims in 5 years. And I think that was what we thought, and when I say we thought collectively, but in reality, that's what not have happened. And that is obviously the plan. It's not something that we can be able to say we can give you the plan in this meeting. Obviously, we need to sit down and have a plan. And a plan, obviously, it will involve the special master as guidance in terms of how that plan is supposed to be developed. Of course, taking into consideration what we have experienced. And I think it's very important. What we have experienced and the challenges that we have gone through and what needs to be done to improve such a situation. I would just simply say, Honorable Matthias, that obviously the reflection that is here does not look good in terms of performance. And obviously we must take responsibility. And I think acting DG has already given that. We're not going to defend ourselves that we have done good. We have not. But we do have commitment to improve from where we are going forward. The commitment is there, but we should also appreciate that there are also challenges. Prof talked about the complexity of the judgment, that this judgment is complex, and obviously even the implementation of it, it's not that it's simple. There are many other factors. I mean, if we can hear from what the Prof said, it indicates that there are also other factors that can actually have impact on the implementation. But I don't think that it is a place where we can say we'll resolve it in the portfolio committee. It's a responsibility that ourselves and the special master need to sit and look at them. And I think that's the commitment that also the acting DG has indicated, to look at these issues, obviously to try to do better in the next coming cycle of our work.
I hope you're wrapping up, Honorable Mr. Ndove, because I'm trying to catch up with time, so that there are certain items that we need to cover now before lunch, because their presenters may be having other commitments. Okay.
But in the interest of time, I think I'll pause here and allow Mr. Zulu to take few of the questions that are remaining.
So I will give Mr. Zulu 2 minutes and give the Prof 3 minutes and legal aid also 3 minutes. The rest of the questions, I will definitely ask you to please submit written responses to those questions within the next 2 weeks, so that we are able to look at them as this committee. But for now, I think I will be fair in giving the Prof 3 minutes and the legal aid another 3 minutes to give us some highlights on the questions posed. Thank you.
Chairperson, thank you very much. And I think I wanted to propose that, especially on the specific questions raised by Honorable Adams, that we provide written report to, because she was referring to specific slides in the presentation, if the chairperson and the committee allows us to do so, including the question that has been asked by the Honorable Chairperson regarding the lost applications. What is our view regarding those lost applications? Because there was a campaign which was the...
Chair.
Yes, Honorable Matthias.
Is the gentleman the same gentleman who was presenting here earlier?
Yes.
I don't think he has got any business to reply on the questions here.
Is any business too?
To reply on the questions here. The best he can do is to provide written responses to those questions.
Okay. In fact, I had given him a minute just to say so, that he will actually be providing a written response so that it goes into the records.
We don't want to listen to him anymore.
Well, I don't know whether that should be recorded as well, but but I think we need to be fair to him, let him commit that he will actually submit written responses to our questions before we proceed to the Prof.
Honorable Chair, that is what I requested from the Chair and the committee, that I provided the written responses. Thank you, Chair.
Thank you. The Prof.
Okay, in three minutes. Yeah, no, for sure, Honourable Kuitama. It's frustrating. Many of the Labour tenants that we have worked with in the test cases have passed away. There's one, because the question was raised about funding, we did manage together with AFRA to get some seed money for litigation for a couple of cases. One of those cases was delayed because the applicant passed away. Successor has been named, the matter is proceeding in court. But I think the point you're making is very, very true, is that the original applicants are beginning to die one by one, and it's quite tragic. You know, even the point made by the Honourable Nyambose, I wouldn't minimize that point. In fact, the last time I came and presented to the Portfolio Committee, I don't think you were here, I looked at the extent of displacement and removal over a 20-year period, which actually is from 85 until 2005. And I also gave an account of one of the test cases we're working on where there was extremely brutal abuse of applicants, which paved the way for forced relocation illegally outside the work of the court. So this matter generates a lot of emotion and pain, and it is because of the reasons I put up there in terms of the fundamental rights that have been undermined by the strategies approached. Because do we want to proceed with simply acquiring land and resettling Labour tenants on land with a whole lot of other people with different rights? Because those farms are not coherent right now. So, you know, what we have proposed is new ways of doing it to bring the processes in line with what is required by the law and the courts. And we've agreed, but we're not moving on them. That is my frustration I've expressed. I just want us to move on the things we've agreed quickly, not take long times before we do anything about it, because I've said you're busy with other work in the department, and I respect that, but then free me up. This issue of trying to distinguish between being a supervisor, implementation, it doesn't gel with me. Because if you supervise, you manage, you give direction. It's implementation, it's part of implementation. So to try and disaggregate that and say you're just supervising, you're sitting in Pretoria and other people are doing things. Hopefully we reach that stage where the officials on the ground are sufficiently capacitated and understand the processes and can do it. And then the focus would be more on evaluating and monitoring what is happening on the ground, the pace, and how we can speed things up. So, you know, we do co-create things together, but then we don't follow it through with implementation. So if we could really have co-supervision, that would be the ideal. Because I'm not here to say we are different to the department. I'm here to say, let's accept the mandate and let's get on with the work, but do it differently so that we comply with the law, we comply with the Constitution, and we address the issues that Unyambo said, if we can come with your issues that you are taking, then we can address. We will be in a position to address the issues. It will require a lot. That's why we came up with the affirmation fund, because you've asked what that is. We haven't been that successful. There's different streams within it. The one is to support litigation. The other is to support a ground force, if I can put it that way, to capacitate Labour tenant activists in terms of paralegal matters so that they can give direct support on the ground and enable us then to get matters to legal aid in a way that is more perhaps ready for them to act on. But also to begin to say, okay, if we need to collect basic information before we go to court, then we can have people administering questionnaires. After all, when Stats SA does a census, it uses matriculants as enumerators. So the basic information required about the 3 generations that will allow the court to affirm that this is a Labour tenant in a court ruling is not rocket science to collect that. That requires oversight. It requires supervision to make sure it happens. But by the time a court referral is made, if we are not just saying this is the applicant, which is what all you're going to say on this Form 6 that they fill in, but rather to say this is the applicant, this is the parent of the applicant, this is the grandparent of the applicant. And then other basic information we have. I've spoken about the geospatial information, which is quite possible in terms of the exact pieces of land that are being claimed by the Labour tenants. But also the changes in the availability of cattle, because the abuse you're talking about, as you know, involves mass impoundment of cattle over decades. Obviously, the CARA legislation, the Conservation of Agricultural Resources Act, has been used as an instrument to deny black people on farms to cattle. And then they get fenced in, and then by the time you're going to settle you're going to settle claims based on where someone is and they've been fenced in, you're giving them a place to live, you're giving them a residence, you're creating a rural slum. And that's my problem with these matters that were settled through other programs. We're creating rural slums in that way, and that's what we've got to change. So in the affirmation fund, there is an element that is dealing with sustainable development post-settlement. And in that, we do have some promises, if I can put it that way, from the Food and Agricultural Organization, and to some extent IFAD, that they will assist. The DG actually helped us with that particular application, and the minister also wrote a letter of endorsement, the previous minister. So we'll still ask this minister to look at that as well. So I've gone over the 3 minutes, and I haven't answered all the questions, but I've just tried to talk to some of them in the spirit which I think we need to move forward. So if there is an implementation plan proposed for the next 5 years, it's fine, share it. Let's talk about it. Let's make things happen. It doesn't have to be our thing to be legitimate. If the department has ideas, definitely we have been co-creating, but it's the action that is lacking. What follows the co-creation of a plan or a system or whatever? That's what we're looking for. The action which implements. Thank you.
Thank you, Prof. Legal aid. Thank you. You have your 3 minutes as well.
Okay. Good day, Chairperson and honorable members. I'm Setopo from Legal Aid. We have noted questions and then we will provide them in writing. But however, I want just to comment that yes, indeed, we appeared before the committee and then we made commitment that we shall continue to provide legal services to a labor tenant, and indeed we are continuing to provide that. And if you look at our statistics, we said we inherited 218, and to date we have managed to finalize 141 that we have inherited. That is 65. I know that it's not enough, but it's 65% of the matters that we have inherited, and then 358 that that are new. 70%, which is about 240, we received them last year, so they are recent. So we believe that yes, indeed, we are continuing to provide, but not at the speed and pace that we would like it to be. And then, honourable members, it's when we were here, we also highlighted the fact that we have budget cut. When we inherited or when we got this mandate, the mandate was unfunded, and then we made plea with this committee that at least if we can maybe be supported to get fund for not even get fund, but not to have budget cut from the national treasury. And I think your plea has helped, because at least with the contingent liability that we said we want a fund for, we ultimately got that money for contingent liability. But the annual allocation is still not enough, but we will continue to provide legal services with the little that we have. Unfortunately, if we have a budget cut, the only thing is we'll keep on getting cases, but then we have to allocate it to limited resources. Then we end up having overload. And overload, unfortunately, then it causes some cases to be postponed. Then hence, the Honourable even indicated that it is taking long. But with the little that we have, we believe that we are providing. For all other questions, yes, we have noted them and we shall provide responses in writing. Thank you.
Thank you so much, Legal Aid. Back to Acting DG. Half a minute.
Yeah, no. Chair, I think we've attempted to answer some of the very hot questions in the room. Again, all I can say is let's reset the pressure meter. We commit to working with our partners. I can't say more than that. I think we're going to give all our answers in writing, that especially specific questions. We've listed them, and yeah, I look forward to when I return here, that we have a more conducive environment for progress and for dealing with these matters. Thank you, sir.
Well, thank you. Ms. DG with your team. Thank you, honourable members, for your contributions. But from the chair, I think I would actually like the department to submit a list of these proactive, these plus farms with existing, unresolved labor tenants applications, and further indicate by when it will actually transfer the farms in settlement of the Labour Tenants applications. 2, in the interim, consider the human resources capacity needs and set a time frame for establishing capacity to deal with the claims. And I think this is very urgent. And thirdly, submit targets for settlement of Labour Tenants applications in 2025-2026. We note that the APP does not actually have targets, so the department must use operational plan targets. That's our view as this committee. And we request that the targets must be actually communicated with the special master, because the revision of the implementation plan targets without the special master's consent is just unacceptable. We just heard that there has to be compliance with the Land Court Act. We also need to discuss the matter of legislative amendments to allow for new applications. Also taking into consideration the implications of the Lamusa judgment, especially the need to finish outstanding claims before opening new claims. I think the reports that that I have requested must be actually submitted to the committee within the next 2 weeks. Acting Director General, let's please see some change and some movement within the department. Because if things are not changing, I think we are going to now begin to ask for very detailed report on operational matters. What does each member of your staff, acting DG, do on a daily basis? And we are going to actually put your divisional DDG on the spot. Perhaps it might actually we need to invite even your chief directors to be here. Somebody, I mean, everyone must talk to us, must tell us what do they do on a daily basis, so that we are able to put our fingers on the nub of the problem. Why is there no implementation of things? Then I think, I hope we'll not actually get to that far. But I can promise you we are getting there if we don't see any movement in terms of implementation of programs and decisions that actually have been taken here. The civil society representatives.
Chairman, I know you are time constrained, but please can you allow it 2 minutes stretch break, if you don't mind, unless colleagues want to continue.
But without members leaving the room, you can actually stand and stretch for 2 minutes here. I mean, for that you need a minute. Even responding to the call of nature. Thank you. I would allow that. Let's stretch and. In the meantime, AFRA could actually be loading their presentation. The AFRA representatives, which is Mr. Stolle. Okay, you could be loading, Joel.
We're still waiting for you. Was it at Knoflook around?
Okay, we'll talk about it. She is responsible for all of that.
But I met the minister this morning.
Okay.
He asked me, when are you going to send the date that we go to West Coast to visit the areas? So I told him I can speak with my own Indian Dominic.
Okay.
They can arrange a date.
Yeah, that will be fine.
168 sites.
Oh,
Yeah, the minister said we're going to do it on a Sunday and a Saturday.
okay. No, that will be fine. Okay. Honorable members, can we please come back and resume our business? Honorable members, please come back. And our visitors, can they also please come back? Presenters, please come back. Please come back. Come in, come in, come in, please. We are ready to resume our business. Okay, thank you, honorable members. We are now ready to actually receive the presentation from Mr. Stolle, who represents AFRA, the Association for Rural Advancement. Over to you, Job. You need to actually put on your mic here.
Okay, thank you so much, Honorable Chair. Ngibingelele ngokuhlonipha okukhulu to all honorable members, to Minister esehambile, nabo bonke abasebenzela lelizwe kuhulumeni wethu, ngi-observe protocol nje ngendlela efanele. I must thank the Portfolio Committee for its wisdom in having a specific session to discuss this important matter. Most of us have principals, and when we received the invitation, we were then deployed to come and deliver presentations. I would just like to share that my principals are the actual Labour tenants that have sent me here. And I sat there and I'm sitting here now trying to hold back emotion because it's been too many years sitting in platforms such as this one. And when the people that we work for send you to Cape Town, I'm from KZN, Pietermaritzburg. When I have to fly to Cape Town, and I sit there and I realize that we are exactly where we were when we brought this matter to court. It hurts. But I do thank the spirit of honorable members that have spoken with passion about the need for change. And it's never time to give up. I think in the spirit, as the acting DG said, that we need to reset and find a way to move forward together. My slide that I have, that we are all seeing right now is of Mr. Mwelase. So most of us know this case as the Mwelase case. It's an internationally known case now. It's a case that delivered the first in South African law in terms of the supervision that was ordered by the Land Claims Court and confirmed by the Constitutional Court. But Mwelase is just a term for academics that they use in terms of precedents, Mwelase. But I happen to know Mr. Mwelase's family. And I have learned over the years, and this particular example taught me. I was younger then, but it has taught me never to make promises I cannot keep, because I promised his family that when we succeed in court, they will get their land. They still don't have their land. And I'm going to go back to Pietermaritzburg, and I'm going to deliver a briefing in terms of how this went, and I'm going to tell them that you're still not going to get your land. So I must learn to never make promises I cannot keep. Chairperson, I will not take long because there's absolutely no need for me to go through the history and background. The presentations from the Special Master and Legal Aid have shared where we come from, what the history in terms of this case and the background. But the important thing is that as AFRA, when we brought this case in 2012 in the Land Claims Court, it was simply because individual labor tenants were taking public transport, coming to our office from 2002 onwards, saying that I have lodged a claim to own land, but I have not received any progress, I do not know what's going on. And these were individuals who were coming over and over and over. And at some point, we then decided that we can't help these people individually because we've realized that the merits of their matter or the facts are the same nationally. We therefore brought a class action, which has led to where we are today. In my presentation, I included a timeline. And so I'm going to skip the background, as I said. I included a timeline only because I wanted to illustrate the number of years that have lapsed and the number of interventions and the effort that has been put in trying to find solutions that has amounted to very little in terms of changing people's lives. Obviously, this started way back when former President Mandela signed the Labour Tenants Act in 1996, which was simply trying to restore the dignity of what some in this room have called slaves, to restore the dignity of people who have lived on land for generations. Those people came out in numbers, lodged their claims. As Legal Aid, Mr. Mpenza shared, many were unable to, for many reasons, including landowners who prevented them from going to those areas where claims were being lodged, including lack of publicity. Some people didn't even know about this. But in effect, what we've done is we've said that if you were not able to lodge, then you have no claim to land in this country, just by a simple act. Years went on, as I'm sure other members have viewed the presentation, so I will not read the presentation. There were times under former Minister Nkwindi where there were attempts to negotiate out of court, where the department approached AFRA to say, no, let's not advance this through litigation. Let's sit down and see if we can build a program to settle labor tenant claims. We were excited, and it was done at the time seemingly in good spirit. But that is exactly what causes my fear when we sit here and we will then come up with recommendations to say, go sit down and in good spirit agree. For us that have done that, and it amounted to nothing. The reason those negotiations failed is because the department made promises. The department said, we will do A, B, C, D, and we gave them time to do those, and they did none of those. We then proceeded to court, which is why we are here. So I'm just putting that red flag to say, when we agree to go somewhere to agree, it's not going to lead to what we expect unless there is the change that the acting DG spoke about. In 2019, the Constitutional Court, Justice Cameron delivered this groundbreaking judgment. And again, I think the Special Master is correct that it is a complex judgment, but we need to read the judgment to understand what the Constitutional Court confirmed and ordered. It wasn't just simply that have a national program, appoint a Special Master. The judgment talks to the delivery of land to people who were abused over time. The judgment talks about changing people's lives, giving them dignity. It talks about, it's not, that is why I depending on who you report to, the word finalized, when we see presentations about how many claims have been finalized to me means nothing. It's a tick box exercise for someone who reports to someone in terms of how many claims you've settled. How many people's lives have we changed? That presentation of 500, whatever the number of claims that have been processed, I work on the ground, and I will show you in the next meeting how many of those people remain in the same situation or are worse off, because it was a department or a government coming to say, here's land, and then they leave people just like that. So, but this is not that platform. In the next meeting, I will display or illustrate what I mean. This slide has been seen. I think the Special Master shared, and Mr. Zulu from the department shared the progress over the last 5 financial years. And I don't know what can be said about this. When you have a target of 6,500 and you actually deliver 510, and now we sit and we put resources and we talk about continuing for another period of whatever time, 5 years and probably more. If you look at that trajectory, judging from what's been done, the Special Master illustrated the number of years it will take if we follow the same process. I don't see why we should continue in the same way. Luckily, we were able to successfully petition the Land Court a couple of months ago to order or direct that there must be an evaluation of the last 5 years of this program. And we have the opportunity, the Special Master and the department will lead that process, and the Special Master has started that process by developing the framework for that. We hope we will comment on that framework, but the most important thing, again, it will be about having an honest reflection. If we are not honest, then we will just keep doing the same thing. I know that the attempt to work in good spirit, it is what informs us in meetings such as this one to be friendly when we speak. But if we are to change people's lives on the ground, we have to be honest. What doesn't work, doesn't work. We have to be honest. And we will do it outside of meeting. We'll have other meetings where we can be honest and agree to be honest and talk truthfully about what has happened over the last 5 years. I sympathize with the Special Master as an agent of court, that I see that in his assessment and in his report, he is very friendly when assessing the delivery by the department. I respect that because we have to work together. But I do think we need a platform where we can sit with the department with nobody else in the room and have that honest discussion to say, we're not in a meeting where we are trying to defend anything. Let us truly talk about what has not worked. In terms of compliance, I will not repeat. Luckily, that's why I will cut this presentation short, because the Special Master has covered me in that. There was a process of developing a compliance register, and the Special Master shared the number of years that have been lost. But I have never sat down and looked at that register in a way to fix things. It's a document that was produced. The department commented on that and pronounced itself in the court hearings, but that's that. These documents must actually lead to engagements to fix what is not happening. So I think there are some recommendations both from Legal Aid and the Special Master that cover that, and as well as the comments from the acting DG. Now, for me, this is, as I said, that I'm sent here by people that actually live this problem, that are suffering this problem. And when I engaged the leaders in the communities that we work with, and I engaged some directly, some of the claimants, and I said that I have an opportunity to go to Parliament and speak to those that have been empowered by our Constitution to make legislative measures to help you. And I asked, what should I say there? The first thing, which again, I'm sorry that I know we like to have meetings where we speak about collaboration and working in good spirit. But those that are suffering this problem have recommended that, yes, it is correct, as the Special Master shared, that the Constitutional Court did not find against individuals. It found that there were systemic failures in the department. That is correct. But there is an order, which in effect is a judgment debt. There's an order that directs, does not give the department a choice. It directs or it compels the department to deliver on a national program as pronounced in the judgment. Now, after that judgment, when individuals in the department that are empowered to deliver on the program are not delivering, those that have sent me here have asked us to now explore contempt of court proceedings. And this is not something that we are creating. Judge Meir of the Land Claims Court, I've included the minutes of that hearing there in that slide. She pronounced in that hearing to say that this continued repetitive non-compliance by the department will eventually and inevitably lead to contempt of court proceedings. That's not me saying that. That is Judge Meir of the Land Claims Court who said that. And this was 2 years ago or a year ago. We are now in 2025, and what Judge Meir was talking about needs to be actioned if there is no change. Now, that's a very difficult statement to say when I say if there is no change. Who am I? How will I assess that there will be change? How long should it take for me to say, no, 2 months is enough to see change, or 2 years? I don't know how to follow that process. But those that mandate me to be here want accountability, and this is the first recommendation that they are suggesting. The second recommendation is that, as I said in the beginning of my presentation here, that when we instituted these proceedings in the Land Claims Court, when we experienced that the department was unable or did not have capacity or will to act or deliver on the Labour Tenants Act, we then decided that there needed to be special supervision, which led us to study international law and come to a decision to petition the South African courts to, for the first time, install a special master. We succeeded in doing that, but we were obviously wet behind the ears. We had never done that before. What we didn't realize, and in hindsight, in our submissions to court, we asked the court to ensure that the budget and the resources for the special master are borne by the department. In learning over the last 5 years, that is not working. It is not working that the institution that is being supervised controls the budget of the supervisor. There have been so many meetings and activities that have been cancelled or not delivered on by the department that the special master has put in the plan and requested for them to happen. But the department does not approve those activities because the special master has to get his activities approved by the same department that he's supervising. So there's a recommendation from the people on the ground that we need to ask those that know in terms of public administration. Where can you move the budget of the special master so that it's approved elsewhere and not by the department being being supervised? Now, it's not a secret. Nobody wants to be supervised. Nobody would want an external institution to come into a department to supervise your activities. So we know that the department has vehemently opposed the appointment of the special master from day one. And upon the appointment of the special master, the department has done everything in its power to frustrate the special master. That is very clear. So that is the basis for why we say that those that know need to help us in pointing us in the direction of where must we ask this budget to be moved, whether it's Treasury, whether it's the Office of the Chief Justice, I do not know. But the recommendation from the ground is that please remove this budget from those that are being supervised. The last one is covered. I think Legal Aid has covered that one. The majority of affected citizens do not even know about this program. Original claimants have passed away. Babu Mwelase, who I showed you in the first slide, is no more. Mr. Zavalaza Mshengu is no more. All the people that we started this work with are no more. Their children do not know about this program. They do not know that their grandfather lodged the claim. They do not know where the piece of paper to prove the claim is. They do not know. So we are asking that there must be a national campaign to alert South Africans, whether they are still on farms or not. I would like to end by asking for some wisdom. I was not there in Kodesa. I was not there when the first draft of the Constitution was written. I've read the Constitution, I've studied it. I am confused why black South Africans must prove that they are black South Africans and that they are connected to the land in this country. I just don't understand why people must prove that. I don't understand why Labour tenants must prove that they are a Labour tenant in order to be assisted. I don't understand that. It's something where I need someone to school me on to why we are asking those that were marginalized, those that were oppressed, to come forward now. When we go to court, Agri-SA is here and they will share their experiences. When we go to court, landowners come with their powerhouse law firms. And the Labour tenant comes there and the judge and the court expects that Labour tenant to prove that they're a Labour tenant and prove which land they used, where, how, when. And if they can't, they lose that case and they go back to suffer on farms under the hands of owners of land. My parting shot, Chairperson, is that for the reasons that I've shared now and my lack of understanding of why South Africans have to prove their citizenship, we made a submission in the process of developing the Expropriation Act. I am aware that the President has signed the Expropriation Act. I'm aware that it is not being implemented at the moment. Labour tenants, if you were to view our submission, our written submission on that, Labour tenants, we put on that submission as low-hanging fruit, as citizens that are ripe for expropriation with lowered compensation. I don't want to go to nil. Obviously, there are special cases where compensation can be nil, but without focusing on market value. Labour tenants have been using portions of a farm for generations. The owners and owner of that farm has derived no economic benefit from those portions. Labour tenants have provided labor without being paid to those owners of land. They have built up their commercial enterprises without being compensated. And today we are now asking black South Africans to pay tax so that government can use that money to go buy back the land that was taken by how we all know. It does not make sense. And we therefore respectfully ask that as in engagements moving forward and this portfolio committee, that if it can assist us to engage Parliament in that when implementing the Expropriation Act, let us start with the low-hanging fruit. There are millions of hectares in this country that don't need difficult processes where farm dwellers and labor tenants exist, and that land, if owners are not willing to transfer that land or sell that land must just be immediately expropriated. Chairperson, I could go on forever. I'd like to thank you for the opportunity and maybe apologize again if I am emotional. When I was sitting there, I practiced to not be emotional, but I clearly was not successful. But thank you very much, Chairperson and honorable members.
Well, thank you, Jobe. Yeah, I didn't see any emotion in your presentation except passion, for what you are doing, which is actually appreciated. Can I actually call on the representative of the farm dwellers? There is an organization of the farm dwellers, Mr. Mkuna, and someone else, Mr. Mkwena. They will actually share their slot of their allocation of time. Are they here? Can they please come over this side? Thank you, Jobe. Maybe I will ask you to introduce yourself, because these proceedings are actually live outside there by our bona all over. So, Menanja, I don't know who is Mkunu, who is Mkwen. Thank you.
Thank you, Chair. I'm Sake Mkunu, the chairperson of FLASA, Farm Dwellers and Labour Tenants Alliance of South Africa. As a land activist, we've got plenty of land organizations, LPM, Farm Dweller Social Movement, FEDCO, Kinambogoto, Siangoba. So we did come together and try to form one organization that will represent all these organizations. So we name it FLASA. We are operating in KZN and also as at Mpumalanga as well. So we are trying to make our voice heard, because we see that when we are operating as a small groups, the government didn't recognize us. It's been a long time we've crying as labor tenants. As we can see that now it's over 27 years since we've lodged the claims, as the previous speakers had said. But till to date, we are still waiting, and it's a shame. I also lodged a claim myself. I was young. Today I'm turning gray. Yes. But back then, I think it was 1998 when I was lodging the claim. I was a young, fresh boy, but now I'm an old man. No results on my applications. So we are glad today to be invited to this committee of the Parliament, this portfolio committee of the Parliament, because it's been a long time. We wish that one day maybe our cries will be heard. One of the instances, the people back home, they said, no, Mkun, when you are going there, ask the Parliament that we need someone who will represent us at the Parliament, because our voice is not heard. But today, I'm glad to see that this committee knows that there are people living on farms. This committee knows that there are people who are still suffering on farm. It's been so many years since we get freedom in South Africa, but the people on farms, the labor tenants, they never enjoyed those fruits of freedom. We are still suffering as if we are not living in the same country as anybody living in South Africa. We are always asking ourselves, when are we going to be free? When are we going to have a right like anybody? We don't have a right to build houses. When your house is falling apart, you can't revive that structure. You got to have to talk to the landlord and say, hey, look, boss, indlu yami manje ekhaya iyawa, my house is falling down. He will say, no, you are not allowed to rebuild your house. You rather go and seek the land somewhere else, not in my farm. Whereas the whole of your life you've been living on that farm. Your grandparents were there, your parents were there, even you are there. But you can't. Maybe the house I'm talking about, your grandfather was staying in this house. Your father was staying in this house. Even you are still staying in this house. We are increasing as generation. We can't live in 3 rooms. If the house is 3 rooms, you can't build a 4th room because you don't have a right to do that. I vote, we voted. We always vote. What are we voting for as labor tenants? What are we voting for? It's like our vote, it's good when it's a voting time. But after elections, nobody cares about us. That's the problem we have on farms. You see, when you are living in a farm, it's like you are not a South African. Even to your fellow citizens, once they know that you are from farm, they can say, hey, why do you stay on the farm? Why can't you move on the farm? Why do you stay there? Hey, I can't stay on the farm. You see, when you're having a problem with the landlord, you go to the government officials in the department offices and say, no, I've got a problem here. Hey, this landlord is troubling me. The officials will ask you, why can't you move in his place, in his area, in his land? Why do you stay there? The officials, government officials, sometimes we even confused whether they are working for government to serve the community or they are paid for to protect these landlords. We are having a problem with them. We are seriously having a problem with them. Yeah. In district offices, in provincial offices, it's the same. We are having a problem with them. They are not there to help us as a poor black people who are residing on farms. We don't know. You see today, maybe mhlambe ngizolala kahle namhlanje ngoba ngikwazi ukufika eParliament ngahlala nani ngabona ukuthi kanti lento yethu iyaxoxwa kusho ukuthi ukukhala kwethu kuzohamba kuhambe kuzwakale yabo kuningi ke. There are so many issues you see. There is these RDP houses somewhere where I came from. There are RDP houses. The municipality or the government bought the land somewhere else out of the farms. All the farm people with the farm with the labor tenants applications. Once you've applied that RDP house, so you don't have a right to stay here. You have to move because now you have a house somewhere else. We were told that by so doing you are waiving your rights. You are waiving your rights, but when you ask that to the department official, they say no, it's good. Move away from the farm. Isn't you got a house there now? don't stay in the farmer's land. So that's a problem. It's another way that people's rights are always getting lost along the way. You see, because now we don't see that as a good way of doing things. We were told that when someone is leaving, whereas he was having a claims, that DG must sign that that person has moved from the place, which meaning he's waiving his right. But we never see that action taking place. But it's happening in front of the government officials from the rural development. Why do they skip the procedures? Is it lawful or is it unlawful? If it's unlawful, who's holding them accountable for that? Because now by so doing, the landlords, they are now having the right to lend for them only, helped by the municipalities and other government officials, while people will go on crying and say, no, look now, we've got no land. Because maybe 5 years down the line, these people will cry and say, no, we remember that the farm life that we were living, it was better living on the farm than staying here in the RDP houses. This is the other thing maybe this committee must look at. How can we help the people from farms? To have these RDP houses built direct where they are staying. Not because I need the RDP house, so now I must move from the farm and get the RDP house somewhere out there. My rights are here on the farm. I don't want to leave the rights, my rights here. I've heard that it's true what you are saying, that people are dying. My grandfather died. My father died, passed away in 2022. I will pass away very soon. The information to our generation is getting lost.
How do you know that you are going to pass on very soon?
I know, I won't hesitate that everybody knows. But once you know that you're going to die, it's pressurizing you, man. When will this thing of our application, when will it come to an end? We want land now in our lifetime, you see. That's what we want. We are the activists. We are leading people who are suffering. We don't want to be seen as liars when we say people one day they will be free. South Africa is free, but people on the farms are not free. Because I've got my colleagues to share his information as well. I'd like to stop there, but thank you for all the input we've had today. We've got something to report back at home, but there's so many things we can say. Please continue helping us. Maybe God will hear our pleas. Thank you very much.
Thank you, Macingwane. That's a very emotional presentation. Thank you. Over to Mr. Mkwena.
Thank you very much, Chair. I'd like to greet all the honorable members of Parliament and Office of the Special Master, Ubaba Ngubane, Ubaba Ujobe from Afra, Nabobonka Bakona, ama stakeholders. Chair, I would like to bring it on board that the difficult measure that we've got, I'm a Labour tenant, I'm still a Labour tenant. I'm residing on the farm called Coppermain, that is under Steve Tshwete municipality in Middleburg in Mpumalanga, where the minings are taking places, where they are abusing the Labour tenants, where the farmers are abusing the Labour tenants, which is the most difficult thing at this point in time, because we thought that at this time, 30 years down the line, there would be different. But there were hopes that were coming. when the Office of the Special Master intervened in some of our cases in those areas. But I would like to put it clear to the Parliament that the Office of the Special Master is trying its level best with its team, including Mr. Donovan Williams, Mr. Jola Olu, and Mr. Reggie Kanzi, which they are always with us on the ground, together with the Special Master, seeing the difficult measures that we are having. But the way they are pushing their best, I will put it clear to the Parliament that the department doesn't play its role to assist the Special Master, because we are the activists who are always on the ground and who volunteered to help the Special Master with all the organizations that have been said by my colleague, Mr. Mkunu, all the way from Mpumalanga, KZN, right up to Limpopo. We're always on the ground with the Office of the Special Master, and we know the difficult measures that we are coming across. In some instances, they will inform the Special Master that there will be some officials to come and assist, but at the end of the day, they don't come out, they don't pitch out. And as much as he tried, some of the resources are so limited in such an extent that in terms of logistics and accommodations, for us as volunteers to assist him, it had to come from our pocket while we are assisting. So it's really a difficult measure that we come across. So I'll put it clear that I cannot hide it. What is being said by Ujobe of Afra, it's true, because we are always with them on the ground. And at some stages, they come with a very charismatic ways that this is what we have done, and this is what we are trying to help in assisting in that, but actually it's not happening. The truth is that we are staying there, we know how it's happening, and it's exactly what is happening. For an example on display, there was the money that was invested by the Department of Rural Development for the Labour Tenants. That is 115 million for black economic empowerment to one of the farms called Alzu. That was in 2008. That was invested to that farm. So we went to the department and explained. Sorry?
The name of the farm?
The name of the farm is Alzu Farm, A-L-Z-U Farm.
What about is that exactly?
It's under Steve Chwede municipality in Milbeck, Mpumalanga, Nkangala district.
And what was the amount?
The amount that was invested, it was 115 million, 115 million, as a part and parcel of black economic empowerment.
And Alzo is very rich.
Yes, it's true. That's true. And what had happened, we tried to engage with the department that can you please intervene, because the department said they've invested this amount for us, and the farmer confirmed that yes, it is. But now the pity part about it is that you don't get any financial year-end statement that states that this amount has been used for this. You don't get the AGM's meeting that stating that the money has gone so far, and then this is what is happening, this is what you should expect as a beneficiary for the yearly dividends. And the trustees committee that were supposed to be appointed by the beneficiaries were appointed by the directors of Alzu. And what happened, while the Office of the Special Master came, and we thought it will enlighten the load in our shoulder. And eventually they did try their level best to intervene with this matter, because the department said, no, the Alzu said they've got good relationship with you. Why should you cry and all those things? Whereas it's the same farm that it's leading with eviction of people who are staying on the farm. The very same farm. As I'm speaking, I've got two urgent applications that were lodged against me for revealing this thing. The other one was heard at the High Court yesterday as I was on my way to Parliament here. Just to suppress you once you start talking about that amount of money, and then they start suppressing you that you mustn't say it. Remember, I'm a labor tenant. And then there was money that was invested for me to benefit. At the end of the day, it's a double tragedy for me. Because I didn't benefit from that money, yet I'm still a victim of getting my land back. But still, the very same farmer that was saying that he's going to change my life, he's still suppressing my life. And the matter was taken, because they were said it was allegation, it was taken by the BEE Commission. And I will put it in front of the Parliament that what I've said, it was exactly what has been said. And I've got the documents that it's on public, that I will put it to the Parliament that it's exactly what I said. That there was fronting and there was money laundering, and then people benefited on the name of labor tenants, on the name of black people. And then the special master even went further, said, let us have a forensic investigation. And then it went on, I think in 2023. They requested the DG to have a service provider to do a forensic investigation. And later on, I think in 2024, they said they are done with a forensic investigation, but the special master can put it on board. He still struggled to get that forensic report. Nobody wants to bring it. I've sent even emails, even last month, I can prove that we are waiting for the forensic report. And nothing happened on that. And then there were even suggestions that, look, this matter and the recommendation from the document from the BE Commission stating that, look, this is the money for the beneficiaries, this is money for the labor tenants, and they must know what is happening. And they requested that, furthermore, let this matter be taken to the SIU because they've got all the resources of investigating all this money. So I'm trying to put this thing on board in such an extent that we as labor tenants is really difficult in those areas, while there are also mines that are abusing our people, like the mine called Optimum Mine. You know, everybody's got a historical background of that Optimum Mine that was owned by Tegeta, and it has moved our people, our labor tenants were forcefully moved from the farm and were taken to the township called Rockdale that is under Steve Tshwete municipality. It was not within their wish list, and they're forcefully removed. And it is what had happened. And some few mines are still doing the very same thing. There's one mine called Mafube Mine. There is a family of Buddha with the Umkulu Buddha and Ugogo Buddha after they were harassed. I'm talking about a year ago. The pity part, due to the stress, they both passed through this world. Due to that. And the officials of the special master tried to intervene in that matter, and they agreed that there should be a mediator. And that was appointed by the department to go and mediate. And later on, the mediator was stopped by that very same department without notifying this office of the special master. So I'm trying to bring you to the point that this thing, it's not like it's very soft, it's deep. Because all the crises, we can go to the Department of Rural Development and Land Reform in Wheatbank. That's the worst department you can ever go. Nobody has got a trust of that department. Because even if you go and cry there, exactly I'm going to tell you, the farmer will know that you were there. You were there to cry against him. And the worst part of it, nothing happened. So it's really difficult measure that we are having as labor tenants. And it's even worse because the eviction are still going on. And people are not allowed to build houses. What Mr. Mkunu said, it's something that I got yesterday because before I get the flight in Bronkhorstspruit, that there is a family of jail, family. They said, the farmer said they mustn't get in there, they mustn't do any tribal feast, they mustn't rebuild that structure. I'm talking about things that happened yesterday. Those are labor tenants. So we as activists, we are trying in all angles to assist, but we don't have that resources. And even though we try, even some of the police stations, they just call us to come and assist because somewhere, somehow we just got assisted by legal aid which is also doesn't have much power in some of the stages because they are not. I'll put it that they need extra people well trained to deal with the issues of labor tenants because most of the cases they are talking about crime cases, and of which is a difficult measure in our area because they don't have a clue about what is happening. And I think on that, it's not to criticize them, to tell them that let them reinforce to get the right people to deal with the labor tenant cases because we are running short of that. It's really difficult on that side because especially the legal aids we have in our areas. Like there is an urgent case need to be done and they will tell you somebody who will engage with somebody and until the date come and then obviously they're going to win. We're going to lose. So in that matter, I would also request the department or the parliament to also assist in that because we need the well-trained legal representatives who can deal with these matters because all the farmers, once you touch him and then it's go to his lawyer and then he can act immediately without any hesitation. And if you don't respond, it shows that you didn't listen to the court and you misbehaved. That's a long and the short of the subject. I think to close the matter, I would say it was really a great opportunity for us to be part and parcels of the parliament. Hopefully it will enlighten the load on our shoulders and to be on the ground, to see things, what are things happening, because we've seen the role that has been played by Special Master and AFRA and Ubabu Ngubane trying to assist in order to make the activists and all these organizations that we are leading to make things successful. It's not easy at all, honorable members. It's not easy at all. We are using our resources. Sometimes we risk our lives to save our people. But we said whatever that might happen, let it be. It's better to die being a hero than being a coward. And we are prepared to die for that. It's not like what I've revealed here, it's something that is going to be light. I'm going to be targeted. I'm a target, obvious. That's what they want, because they said, I've voiced something, I've touched something, I've touched somebody's nerves that I shouldn't touch, because you know sometimes they come say you have touched the untouchables. So, but I'm here before Parliament to say whatever that might happen, I'm prepared, but if this, what I'm going to give you, it's true, that's genuine, that's something that cannot be hid, and that is a statement that cannot be changed. And I thank you, Bond.
Hey, thank you. Mr. Mkwena, and thank you, Makungwane. I think it was, honorable members will agree with me to say that it was a worthwhile exercise that we actually invited the people who are directly affected by what we always talk about in our committee meetings. Without any further ado, colleagues, we are running behind time. We are trying to chase our time. I will ask Dr. Ngubane Mbomvu to say something to us. And then after which, honorable members, we will break for lunch for 20 minutes and then come back and begin to actually engage on the presentations that have been made by all the presenters, including the two presentations that have just been made. Mbomvu, you have the floor. Can you please speak to the mic?
Honorable Chairperson, honorable members of Parliament, my name is Mngobi Ngubane. I'm originally from Muden in KwaZulu-Natal. I have been working with the Office of the Special Master, trying to assist with research purposes and also to train the activists in conducting oral history interviews. So without wasting time, I would like to show this film that I have produced in order to assist the process of former labor tenant households to finally get their land back. Thank you. I would like to play it. And maybe the lights so that we see it, if it's permissible.
Mbombo, how long will it be? Do you know your film?
Oh, it's
No, it can't be 3 hours.
it's 39 minutes.
9 minutes.
39.
39.
Yes.
I'm going to be guided by the House. How do we handle that? 39 minutes. But it's important. It's a pity that Mbombo cannot actually talk to the film. And okay, let's have a look at the film. Okay, the honourable members agree. That's fine. It will come back. Okay. Outside people, I'm not too sure whether they will be able to capture the film. I don't know how technology works in that regard.
Honorable Chair.
Yes, Honorable Matthias.
Kutama says I must say this because he's suffering, he's fighting flu. That the only reason that he agrees with these 39 minutes, at least before he dies, he will have an opportunity to watch a bioscope once more.
Okay.
Take it out completely. Yeah.
Okay.
Break for lunch whilst Dr. Ngubane is actually sorting out issues around the volume so that we don't have a minute to waste. Yeah. Okay, can we then break up for lunch because lunch is ready? Now our lunch is a sit-down lunch out in Max Building cafeteria in the cafe there. Then, because it is far, then I will add another 10 minutes so that we break for 30 minutes, unless Dr. Ngubane has sorted out things.
It's not yet sorted.
Oh, okay. We can then break for 30 minutes, go downstairs, have lunch at Max Building, actually, cafe.
This.
uMandela washicilela umthetho owanikeza igunya labantu
Specific areas where you can, when it comes maybe if you think,
I'm not sure whether the DG is still around.
are there those portions or you just, because I'm worried that they will stop.
We can skip where Prof speaks. You can skip that part.
Is it not any, it's something that he's already said?
Yeah.
Okay, see how it goes.
But then what I can do is I can share the film with everyone else, so that people can just also watch at home. Yeah. In that way, we can, if there's a need to stop, then we stop.
Okay.
And then we distribute the film.
Yeah. Okay, let's maybe do first 20 minutes.
Okay.
And then see how far it goes. Or maybe at 30 minutes. Maybe the compromise. Okay, maybe compromise be at 30 minutes.
Honorable members, honorable members, please, may I have your attention, please? Under asseblief, can we resume our meeting? I just hope that the technical glitch has actually been resolved. Okay, over to you, Mbomvu.
wazalelwa eplazini likaFlepa ngo-1932. Eseyintombazanyana wayesebenza endlini yomlungu, eshayela, epheka, ewasha. Wayengixoxela ukuthi uma eyotheza, uma kuqhamuka imoto yomlungu, wayelala phansi ethi ne ngesisu, enzela ukuthi umlungu engamboni. Ekufikeni kwabo iziqhawu ezahlukahlukene, ezinqola nangamahhashi babulala, bachitha igazi lokhokho bethu. Basungula uhulumeni wabo, bashaya imithetho egunyaza ukusephuca kwabo iswe. Kule ngxenye enkulu, izizwe ngezizwe zavunyelwa ukuhlala lubhojozi, zaphenduka izigqila zabelungu. Zisebenza mahhala, zingaholi. Konke lokhu zazikwenza zinqenge indawo yokuhlala, zinqenge inhlabathi yokulima nokufuya. Ngo-1996 uMandela washicilela umthetho owanikeza igunya labantu abahlala emaplazini lokufaka izicelo zokubuya kwezwe. Kuthe kufika inkululeko, izinkulungwane zezizwe zabakhonzi nalabo ababeyizigqila zabelungu emaplazini zabe sezichithiwe, zaxoshwa, zalahlwa emikhukhwini nasezitendeni kulo lonke leli. Yini umnqobi Ngubane, ngakhuliswa ukhulu, ingakho namuhla ngizabalaza kanye nani ukuze umhlaba ubuye.
Ngiqhubeke njalo ngilime, ngiqhubeke ngifuye. Ngilime ngentanga, ngifuye ngentanga. Ngoba umhlaba uwenu. Manje uMnyango wezindaba zokubuyiswa komhlaba wathola izicelo ezingama-20 ezinkulungwane nezinkulungwane ezimbili. Ngeshwa uMnyango wezindaba zokubuyiswa komhlaba wehlulekile ukubhekana nazo zonke lezo zicelo. Ingxenye enkulu eyevile eshumini lezinkulungwane azikaphumeleli, ezinye sezalahleka. imfe imfe ma nointshontsha lapha nikhokhobe wa fini ni shy pants la nibophele la maqakale la manihamba then uyikhudu yakulandela ibophele la
Yangibona semngindi.
yes
Uphekwana ithosibuyela ngesigodi.
Sisikepe senu.
Uphekwana umfana climate sihamba lematini. Isigodi sishayile. So kwemanzini.
Yes.
Uphekwana bambe lo yamkhitha. Ufuna phansi lokulisa. Akukhiphe khona kubuye ngaphandle. Ukudla kumnandi yasemngindi.
Yes. Impilo emnandi bafethu.
Emnandi ngoba siyalima, ubamba inkombo, inkabula kuyalinywa. Don't inkabula kuyalinywa. Mangabe bengashaya ngeswebhu la. Konde la kuyalinywa emakhaya la ngenkomo.
Mhlawumbe uzohambe ufuna ukwazela. Inkomo mangabe ukuthi yahlaba nje loze sikukhuza la mina.
Hayi thatha iflexible. Hawu. Thatha iflexible. Yakhala iswebhu la
baba mncane kuyaphaphamisa ulela ile nto zakho inyosi nobisi lokushiwo ebhayibhelini into le singasho kusayibona ngoba naniphume ekhaya nolusi ningabuki ukuthi nizodlani nizobona iy'nyosi nebisi apho nazi iy'nyosi natapha mase niyitapile iy'nyosi nyadla nanku amatulo nani noze nibuye ngasentambama kwanozekela leli yikhaya lobaba uMwelase nomakhelwane babo kwakwakhiwe kunemizi eminingi namuhla umhlaba wabo sekwaba indawo yase-Hilton College isikole esidula ukwedlula zonke izikole kuleli zwe. Mabefika bamhlophe bezokwakha isikolo la babengazi khona abantu abahlala emva kwesikhashana insukwana bekhona bathuka bezithela phezu kwakhokho wethu uMbeki bazithela phezu kwakhe and then base bexoxa ukuthi hawu kuhlala abantu kanti la nathi uMbewe indawo yami le nabantu ababo base bethi-ke baba sakha isikole lapha ngenhla phezulu sicela ukuthi kube khona sithola abantu abazosebenza nosakheni isikole batholakala-ke abantu basebenza la abanye ubamkhulu wababiza ngokubazi ukuthi mhlambe bama-in-laws abakhwenyana noma ama-relatives beza la bazosebenza kusho ukuthi isikole sasingenayo ama-resources amaningi naso ukuthi sakhe ini na umzekelo ukuthi umgwaqo osuka le esikolweni uza la wakhiwa inkomo zasemakhaya boshelwe span of oxen isikolo indawo esakha khona isikolo was donated by Mr. Henderson isikolo ke then sakha ke lapha and they had no business babengahlanganiseli lutho nendawo njengoba ngisho bathuka sebehlangana ubamkhulu wabatshela ukuthi yena ophethe la. Where have you seen a school with such a large and vast hectares and hectares of place? Where have you seen that? Now we look at that as disposition of land, disguised as building the school. Yeah, you see here, where we stand now here, we're standing at the gate into the Kwanozegela. A former Kwanozegela, which is now become the Game Nature Reserve. People were forced removed from Kwanozegela, so they registered with the Game Nature things, you see, so that they would keep the animals here. They prefer to have animals kept here than to have people staying here. If you it breaks our heart to see our place here having become an animal cave. That they have animals trampling upon the graves of our forefathers. These stones that you see here are the very stones that were used to build that kraal. You see, kraal for the cows. Now it fell down as everything was falling down. So then, some stone rolled down there, and some remained, but there's no actual remainder of the round shell kraal made out of stone. The relocation, when they said relocate closer to school now, where you're working, that gave them an opportunity to extend the boundaries of the school, to incorporate also Nozegela. Nozegela now belongs to them. So that was all a ploy. And then the whole area then became Hilton College. So now when we say we want our area, you're not talking about school. School is not ours. We have got nothing to do with the school. All we want is our area here, Nozegela. That is the story of Nozegela and Hilton College. They took our land just like that.
Izizukulwane zakwaNozegela zamangalela umnyango wokubuyiswa komhlaba, zaye zayofika enkantolo enkulu yalelizwe, inkantolo yomthethosisekelo.
Athi sawufuna umhlaba wethu wathathwa bezizwe. Umhlaba wethu wathathwa bezizwe.
Leli yizwe lobaba uMnyandi nomakhelwane babo bachithwa ngo-1995. Izwe labo laphendulwa isiqiwi njengase-Hilton. Abelungu bajwayele ukwakha iziqiwi ngoba uhulumeni uyazivikela iziqiwi ukuze ekugcineni abantu bengawutholi umhlaba.
Athi siyakhala isizwe sikaphunga nomake wasiyalila.
Ukhonzi Plus kwakugqila. Lo mhlaba lona ukuthiwa thina asigqilazeke kuwo siwusebenzele mahala. Wawubuyephi lo mhlaba oba thina singabala sizalwa kuwo? Sizalwa kuwo lo mhlaba basikicela uyaqeda futhi thina siwekobhati ngapha sifuqelwa ngapha. Lapha ngiyasuka ngizokweqa umgwaqo ngoba sisuswa ngalapha azange sisichase nangu-R100 umuzi nomuzi. Kwathiwa nje sukani la. Ngizalwe 1958 le ndawo, ubaba 1925 naye uzalwa le ndawo. Umkhulu wami nguMavalane naye uzalwa le ndawo. Besebenza iplazi nami ngilificile ngimsebenzele kwaze kwafika u-94. Salahlekelwa-ke thina heyo into yonke engabe sinayo. Mina ngithi siyawucela ukuthi asinike umhlaba. Ngoba umhlaba mina phela isikole sami yiplazi. Angicele mina ukulima nakho nje nakho naka nje wabuka ngithi mina ngilimile ukhona nomehluko. Uthi ulime umuntu omnyama. Cha, ngiyalima mina. Mangathola umhlaba ovulelekile. Nengane zami ngeke ziye kuyofuna umsebenzi. Ngoba umsebenzi inhlabathi. Imfuyo, ukulima kuyimpilo yesizwe.
Hayi, yabona khathi sile phansi lapha sikhona sasiwa khona. Besihleli kahle kakhulu. Kule ndawo encane nakhona nginayo-ke ingajanyana yami encane. Ngiyayiphilisa ngayo. Manje sesicindezeleke kakhulu kila. Ngoba kuba nje sisenendaba enkulwanyana. Ngabe ngiyenza nje ingadi yami ibe inkulu ngoba lokho sense ukulima ngakuthanda vele sokade ngiseyingane. Inkukhu ngiyayithanda kakhulu inkukhu. Ngikhohlwa ukuyibala indaba yazo. Inkukhu ngiyithanda kakhulu. Yabona nje mangabe ngizizalela ngiyakwazi ukuyilungisela lapha amaneshinaza futhi kuba nje kuya ngami indawo nginayo. Ngabe ngiyayithandela ihhoko lazo. Ngoba ikakhulukazi ngithanda lezi ezesizwe. Ngisho abanye abamhlophe abaqhamuka la edolobheni laba ngamandela bayeza bezoyifuna la. Bathi inkukhu yesizulu yona esewunamba 1.
Lezi ivande esezilima iwuthando ukuthi lento siyayazi la sihleli khona kumele kube khona esikwenzayo ngoba ukudla kudula kangaka nje uma ngiphucwa mina umhlaba nemsebenzi ingekho nje kuthiwa thina siphile ngakho ngoba umhlaba uyimpilo udla wona. Endawo oqala kade kumuzwa wodwa kade bakhela kade ushoba lona athi uthengile kuye naye wafike nje wasigqilaza nowaye ngaphambili naye wafike nje wasigqilaza nowaye ngaphambili wasigqilaza. Umbuzo wami uthi kanti inkululeko isilwane sini ikhetha abanjani abantu? Ngenxa nje yenyamazane le inyamazane thina sisidale ikhona indala inyamazane sisibuka ke sisejele asikhulekile.
Sibuyiseleni izwe lethu nina besizwe.
If I may ask Mbongo, how many more case studies do you still have to show?
This is the last one.
Thina la sizalelwe la kulomhlaba nami manje sengina 45 years njengoba sengikhehla kwanami. So now akukho la ngizoya khona ngikwazi ukumove ngikwazi ukwenza next video baba wami wasebenza iminyaka esebenza iplaza kanzima ishawe kahle.
Sasiweni mifula sasiweni mifula
awuphili wendaba yale ngomhlaba lokusukhuluma indaba yalomhlaba la kungenzeki la rasemngakhe inyaka dala sicinga lokhu sifuna babalanda phase balubabambe bayeka bathi bayesilungisela basilungisela akubonakala into abayenzayo ukuthi benzani bathe singena kuphi ema-pitteritif zonke indawo ema-emela yikho into elungayo umnyaka ngasemngakhe sekuze hambe nobaba wakho la ekhaya hambe bonke abantu la ekhaya nizahlupheka la eplazini akekho zasilekeleka bathi manje ukuthi ngabe silekelelwa ngubani phela funeka silekelele nguhulumeni ngendawo asinike indawo zethu esayisebenzele siyisebenzela kanzima bangasitholi lutho babakho bangaholi bangatholi lutho bashaywa nje phela la ayikho into kade bayisebenzela la basebenzela nje induku siyayifuna le ndawo shonile manje ilanga lakimi ilanga shonile liyahamba ngoba nini ngihambe le mhlaba ngawutholanga la ngoba nini nginganamhlaba ngoba nini yongisoka lonke amalanga ngivuke ekuseni ngigada ibhuni lilwa nami yilo ukusafele ngitshelo from 1993 until namhlanje uJabi Linman kanye nobaba wakhe uJohan Linman benze isihluko esikhulu la ekhaya kuthe makushona ubhuti wami okuyena wayefake the claim
Ernest Nkampuli. Uthi manga beshona ezongcwatshwa khona la ngaphakathi eCharteni, ithuna lakhe la ngaphakathi eCharteni. Umlungu uJohn Linman wafika nabanye abelungu abaningi bazogqola la ekhaya bephethe ibhamu. So bafika la bazo
Why are you doing that? Why are you doing that? I'm penalizing you. I want other political leaders to see this video. Yeah, I want to penalize you. We will bury my grandfather here because our forefathers were buried here. We wanted orders from you. For God, for God too. Hey now, Mamandu.
Isihlungu esikhulu thina siyakhala bona basithela ukuthi la akwazi ungcwaba. So lento le yangiphatha kabuhlungu. Umlungu lona wabuya
Honorable members, I think respectfully, for the sake of time, may I please pause the documentary here so that I free up your time, but I can make it available to honorable members to watch at home. Thank you.
Can we have our lights back? The lights back. Okay. Well, do you want to say anything more other than to actually offer the film that you have just played?
Honorable members, I am an academic by profession, and I realized that over the past 30 years, academics have been coming and reporting to Parliament every year about the struggles of our people. And I thought maybe through film we can tell a different story, and also to tap into our African spiritualities, because we are spiritual beings, and the land is the land of our ancestors, and it is the land of our spirits, and this is the land that we will spend the next thousands of years under. So it is within a deep sense of love that I made this film, and I want it to please travel. It has traveled all over the world, and please, can someone show it to Donald Trump? Thank you.
Yeah, Angazembomvu, the only snag would be that it is in a vernacular that Mr. Trump would not understand. Well, thank you, honorable members. I'm tempted to ask Agri-SA to actually make their own presentations, and then after which then we engage, because this one. Yes, we have Agri-SA and AFASA. Those are actually organized agriculture organizations. So maybe if we could actually, take their presentations now, then we will make a meaningful, a meaningful discussion when we have seen also the film and also get the presentations of the organized agriculture. I don't know whether Agri-SA representative is still around. Now you can come forward, and if you need assistance with the connections with. So we've got our IT guy here. Yeah. And Mr. Mtombeni and Mr. Who is that? Mtebu can actually also be getting ready, because immediately after the presentation of Agri-SA, then we'll take their presentations so that we discuss all of them simultaneously. Thank you. Over to you, SA. Is Mr. Ravi. Thank you.
Chair, thank you for the opportunity. Thank you for inviting Agri-SA as a guest to this proceedings. This is not an easy presentation for me to make. I absolutely understand the sensitivities and the heartache and the heart sore that is being shown to us and demonstrated to us. But I do think that we have to remind ourselves as why we're here too. I think a balanced view in all respects, and that is not what I'm going to be doing. I'm just going to be presenting on what I was asked to present. But a balanced view in all things is required. And I think this is where we often fall into the trap. And while I was sitting, I was thinking to myself, what have we achieved this entire morning? We've said so many things that have been said so many times before, and we know the heartache. We've been living with it for 30 years. But the delay is what is causing the pain at this moment. While we're talking about the historical atrocities and things that are indefensible to any human being in his right mind, we should be talking about what are the management interventions that are required to enable the government department and the special master to achieve these objectives as far as settling these claims are concerned. That is where we have to be. We have to move forward at some point or another with full appreciation, obviously, for the historical context and the heartache and the hurt, which we're still living with in this day. But that is the problem that we have in this country, is that in 30 years' time, we're still going to be at the same place if we don't start taking action immediately. And this is what I want to present about as far as I can, Chair, and this is a little bit been off topic already. I often get reminded that I should be sticking to my presentation, but it needs to be said right at the outset that this is essentially what we were invited to talk to you about today. What are those management interventions that are required to enable government to settle land tenants' claims within the legislation and the procedures that are applicable and available to them? I see my presentation seems to be absent again. It was there for a moment. I wonder if the IT people could help me assist with this. Oh, sorry, presentation people. Is it coming back?
No, I think it's presentation. F8.
It seems to be showing part of the, of my screen, but not the presentation.
Can I?
Yes, of course.
Do you have it on?
We're back on the screen.
Sure, that's the screen I think we're concerned about. There we go. Chair, so just to introduce myself again, my name is Janse Rabi. I'm head of Agri-SA's Legal and Policy Development Unit, or executive as far as that portfolio is concerned. Agri-SA is an organization that's been around for 120 years. It's the largest organized agricultural body in the country. We're an apolitical organization. We're a law-based organization. And I'll say this right at the beginning. Agri-SA doesn't defend anybody who contravenes the law. Nobody who doesn't act in accordance with what the legal prescripts are, as far as decency is concerned, as far as the law is concerned, in general, will ever be defended by Agri-SA. So what we saw here today is shocking to the core, as I think many people that have attended these presentations have seen before. And I'm not paying lip service to it. This is a real from the heart statement that I'm making when I say this. It's not easy to make these kind of presentations, so bear with me as I go through them. So I think we've spoken about the background. Labour tenancy is indeed the legacy of racially discriminatory laws. The Land Reform Labour Tenants Act was enacted to provide tenant security and land access. Of the 20,000 claims that have been lodged, mostly of those in KwaZulu-Natal and Mpumalanga, we know what the statistics and the figures are as far as those settlements of those claims are concerned. We understand, and it's been repeatedly said today, that the Special Master of the Labour Tenants was appointed following the Mwalazi Constitutional Court judgment to oversee the claim resolution. But then it also has been said, and we acknowledge that fully, I suppose, as everyone does, that the pace of Labour tenancy settlement has unfortunately been slowed significantly. And that has also taken place in the intervening period since the Special Master has been appointed. And we say that is in part due to poor communication with the department and lack of clarity as to the role that it plays. And those points have been emphasized and elevated throughout the presentations and stated repeatedly today. I'm not going to go into the statistics again. They've been said before. There has been a revamped claims resolution methodology, including archival records, oral histories, and geospatial science. There's been reference made to the Labour Tenants Claim Resolution System. We also know that there's been discovery of fraudulent transaction and lost claims that were previously unaccounted for. That's also been stated today. And then there are policy and legislative impediments that a person should also not keep out of mind and not acknowledge when it's at an appropriate forum such as this one today. And this is the point that I was making right at the very beginning, is there's a lack of dedicated budget and responsiveness, and particularly accountability structures within the various departments, including the Department of Land Reform and Rural Development. Apologies for the typo on the screen. There is indeed poor interdepartmental coordination. There's indeed inadequate training of officials, SAPs, magistrates, and others with respect to tenure legislation. There's a lack of a clear framework of solutions for off-farm settlement. These are all the problems that we know. We've discussed them already today. There's a lack of joint resolution process by labour tenancy and farm dwellers under ESTA. There's a lack of enforcement accountability. There's a lack of reasonable redress for landowners in the case of illegal activities, which also needs to be said. Not defending anything, but these are the problems. I think they've been contextualized, they've been said before, and I'm summarizing them in a nutshell for now. The key challenges identified by Agri-SA, and this is really to the point as to where we were and why we were invited to come today, is what are those management interventions that are required to expedite and finalize claims in terms of the labour tenants legislation and the finalizations of claims concerned. There is indeed uncertainty, and this needs to be said, emphasized, that there's uncertainty for landowners due to unresolved and overlapping claims and lack of information from the Office of the Special Master. There's a lack of off-farm resolution options. There's a lack of transparency and accountability in claim verification and communication. There are disincentives for investment in affected agricultural land. And then there are tensions between landowners and claimants, exacerbated by delays, lack of responsiveness, and misinformation. What we want to come to, and I think this is where we want to offer that, and again I have to pause here. We need to also be the light as government, as civil society, as the judiciary representatives that are here in the form of the Special Master. We also have to be the light in coming up with solutions as to how to untangle this knot that we all acknowledge, and all the challenges that I've made and I've shown in my presentation so far already. And we need to come up with those solutions, and some of those are the ones that we make as far as our recommendations are concerned. We need to, and this is a recommendation, we recommend that we establish a permanent, well-resourced unit within the government department and the accountable governance structures for labour tenant claims. So we need a resourced unit, and this is a proposal that we make. There needs to be a mandate included in our governance structures and our decision-making bodies with respect to intergovernmental or interdepartmental cooperation. And that includes the Department of Agriculture, the Department of Rural Development, Land Reform, SAPS, Department of Justice, and others. And then we have to strengthen the Special Master of Labour Tenants by providing an inclusive management or governance advisory body to institutionalise quality assurance mechanisms. This is where we think that we do add something to this conversation today. This is a management challenge to a large degree, by the looks of it, to Agri-SA for purposes of what we were invited to come and talk about. And I think this is where we could talk and speak to one another about how to capacitate government by assisting with those management structures that we can bring to the table to be able to finalise those claims as much as possible. And what the form of that special unit, that advisory body might be, something that a person can talk about. But Agri-SA and others have models to assist government and role players with in this respect. How to untangle this knot, how to be constructive, how to take this forward so that we don't sit here in 30 years' time again with the same situations. This is an unfolding problem as it is, but we need to come up with those solutions as opposed to repeating what we've said all along and know for a fact to be the gross violations and injustices that have been perpetrated in South Africa. And as we've seen on that video, it seems to be perpetrated still. Our position is that we support an equitable land reform that is sustainable and realistic and that ensures tenure security, agricultural productivity and legal certainty through accountable and responsive structures. And that is where the challenge, I think, lies now, is those accountable and responsive structures. We advocate for a balanced approach that protects the rights of both labour tenants and of landowners. And we recommend investigating sustainable agri-villages, growth point settlement models and adequate services and some sort of business employment hub, which we have those models or working models for. This is very much a relationship of trust that we need to continue on, when we go through and we have to acknowledge and we fully acknowledge the emotion and the deep hurt that has been perpetrated, has been in the past and is still being perpetrated, we need to have that continuing engagement with government and civil society, or between government and civil society, to unlock those stalled processes, which is what we're here for today. Our labour tenant reform is a constitutional imperative as well as a moral obligation. Its effective implementation requires political will, institutional reform and collaborative action. And we remain committed to constructive solutions that promote inclusive rural development. Chair, that in a nutshell, I've tried to keep it as short as possible, but that in a nutshell, my presentation for today.
Well, thank you so much, Mr. Rabi. I think the other group is AFASA. Yeah, AFASA. Yeah. Oh. Oh, Mr. Rabi can actually go back to his place. I didn't realize that there were two. You also will have 20 minutes to tell your story, and then after which we will then want to engage.
Chairperson, honorable members of Portfolio Committee, officials and captains of the industry. I don't think we'll take 20 minutes. We as business people talk less than 10, 15 minutes and we are done. Yes.
Fantastic.
Now, I won't dwell much about who is AFASA. AFASA is a union for lobby and advocacy on behalf of African farmers. We are in all provinces. My name is Pete Motepu. You can hear my name, Pete. It's from the farms. Pete Pompis, Pete Motepu. Yeah.
Not Pete Boshoff or something like that.
Almost there. Yeah, but yeah, we've been here from this morning, and we were quite aware that it's all about Labour tenants, but we. Okay. Yeah, but we also decided, no, let's come up with solutions, because some of these Labour tenants are our farmers at the moment, those who have succeeded with their transaction or having these farms under their names. As I said, I'm from the Free State province. I thought that the MEC and some of the managers at his office will be here, but I think they will get the message, because there were a lot of engagement in the Free State and other provinces regarding the land matter. But we decided, let's also zoom into this. People who were, some of them were, before they were Labour tenants, now they are also in farming. But in other provinces, including Free State, I think you're quite aware that even in January, 3rd of January, Minister Nyonso was in Free State to try to ensure that there's no evictions. There are a lot of evictions happening, but now it's vice versa. It's officials. And most affected people are children, especially when the spouse or the husband passed on. Officials from land reform, they will jump quick to remove these vulnerable people. Most of the time, especially when they are busy grieving. And you saw even in television earlier this year, some of people in Lijoeloputsa district in Velkom, they were in the television. Now, we are saying we need to recommend implement protective measures for spouses, children, to ensure for smooth transition of rights after the passing of the family. Now, this is so painful. It's very, very painful. And also, the sad part is we wrote many letters to the office of the minister. There is not even an acknowledgement. There's nothing. There is no communication.
Sorry, Mr. Motepu. Can you actually unpack a little bit about what you mean by officials evicting people, especially
Melkral farm in Velkom, after the late Mr. Not Melkral, another farm, but there were three, including the Melkral. After the spouse passed on, the officials of Department of Rural Development and Reform, they will come and say, you as children and the wives, you are not supposed to be here. Some of the farms were even at a national newspaper. They were advertised. And we stepped in as AFASA. Fortunately, I want to thank the minister. They stepped in with the help of our MEC in the Free State. It was in November, December. Some of the officials from land reform, they were even, we organized a meeting.
Excuse me, would those be government farms?
These are plus farms.
Oh, plus farms.
Plus farms.
No,
These are plus farms. That is why now it's also vice versa. There's this other side that where those who are having resources, are victimizing our people. But also, let's also look on ourselves, trying to manage these challenges. As I've mentioned, we are advocating on behalf of our farmers. But the very same farmers before, some of them, they were Labour tenants, and now they managed to get these farms from government. And also, some of the challenges is, in the past, your Minister Nkwindi, there was this screening committees for trying to ensure that the smooth processing of this land. And these committees were discontinued during Minister Nkwana Mashabane. And there are a lot of gaps then after this committee were discontinued, because there are a lot of things happening. That is why it's so easy as well. After the spouses passed on, the officials will chase these vulnerable people. It's not only that, and many others. Yes, we are also playing a very critical role oversight and assist to ensure that these labor tenants didn't understand their rights in terms of this referring to land tenure. We are also educating them. And yeah, we are winning, but there are a lot of cases across the country. Now, a recommendation is just to reinstate that land screening committees that was there before with AFAS and other role players to ensure that there is transparency. And also, it's so important that these people who were before labor tenants, who got land now, some of well-established people who are in other own farms or Africans, support from the department, some they double dip. You'll get from, there's this program of rural development called LDS, Land Development Support, that Ndobe will know about it. And they will also get it from agriculture. They will get the resources from this side and also resources from this other side. And this disadvantages these other ones that are also wanted to benefit from the state. And this on its own, you know, is chasing our children away. Our children, especially from university, they are afraid to come to farming because they think that farming, there's no business or they will never grow. Now, in the recommendation, I've mentioned they implement strict measures to ensure that we are all winning. And collaboration between government department, municipalities, and other state agents. What do I mean? We are also having municipality land. And in this month, there's a lot of land in different municipalities. And because we have realized that the municipalities, they don't have that capacity to ensure that people are getting leases. And so that our people can, especially those who were, some of them they were from farms, I remember, and they go to the township with their cattle. And if we can maximize, have the bylaws, maximize the production of this municipality land. And because land reform, you are an expert, you have expert in land reform to ensure that we assist our municipalities. Foster integrated planning and resources allocation through cooperative governance. And we are also available to ensure that we assist. Now, I'll try to be short. Allocation of production inputs, year in, year out, all our farmers, they get production inputs. I mean, especially in grains, your fertilizer, seeds, all our African farmers, they get this very, very late. Outside planting, optimal planting window period. What do I mean? If we get production inputs, those who are in the system or to be supported in that particular year, you must definitely know that your yield or your production is going to be low. That is why year in and year out, we can't get commercial farmers. And these farmers, black farmers, they will say, this guy has been getting money for so many years, but it's not growing. Yes, because they're getting funding very, very late, very, very late. Let me stop there and give my colleague here, he will zoom more on the labor tenant as well. But yeah, thanks very much, Chairperson. And we are looking forward as a FASA to have a robust engagement because there are a lot of issues. The first time we as a FASA, maybe after many years, be invited to this committee. Thanks very much.
Thank you, Mr. Mutebo.
Thanks, Honorable Chair, and thanks to the House. I'm David Mchombeni, also from Afasa, a farmer, also a product of Labour Tenant. Indeed, my latter speaker has already shared, and we have listened to all the presentation since this morning, and no one can dispute that really there is a challenge in the sector. We fully agree, and the immediate action must be taken. Okay, now the question is that I want to pose to all the colleagues from the parliamentarians and from the other structures of the Labour Tenant. Indeed, our people are in a dire stage, and they want land, and their rights, they need to be protected. And my plea and our organizational plea while we protect the rights, we must also look into the accountability and responsibility. Because you can get the land, then the question is what happened next? It has been proven in all the government programs. You talk about restitution, you talk about distribution, and all the structures, CPAs plus farms. Government has spent billions to support these programs. But what are the results out of these programs? The results are zero. While we are fighting this battle, let's also empower our people with knowledge, skills, so that when they are in a position to get this land, they need to understand and know that the land is an asset. The land is a business asset. But what is happening as we speak now, it's a total disaster within all these programs. And the question, who must sort it out if we don't pull our heads together? In my personal opinion, we need to review the entire programs. Let me quote the CPA structure. I think it's 2 years back. 2 years back. The results or the outcome out of the entire CPAs that has been formed with this land program, it's only 3% that are productive. Then one needs to ask a question. What is wrong? Who has done wrong? And if you zoom deep, the wrongs are both sides. Actually, I was expecting that the Department of Rural Development will show us figures that indicate all the finances and all the supports that has been given to some of these farmers. And from their report, what are the outcomes? Because we can throw the missiles side by side. Also, problems are lying within ourselves as people who need land. In short, to all the beneficiaries, those who have received the land, one may ask, I was so touched when I see the film of my latter presenter, shows the beautiful animals. Labour tenants, they've got cows. Actually, when you talk about figures in animals in this country, they can be the majority. But the question is, what is it in their pocket with those animals? That's the thing that we need to zoom deep on it. With the current situation of biosecurity, one of the giant buyers of animals, they've already raised the flag that they are not going to buy animals if they don't have a traceability system. Where the animal comes from. We've got a project called with RAMIS, Red Meat Industry Services structure, where we can trace through the brand mark if the animals comes from Umkanyagute up until that animal reach Heidelberg. And if that animal doesn't have traceability record, that animal, you will never be able to sell it. That is coming. Let me assure you. Then now, as a house and as a representative of all these people within the country, what are we doing in order to empower, educate, train, and develop those poor people on the ground? I'm appealing to all the structures that are sitting here and to my principals politically. When they talk about rights, they must talk about accountability and responsibility of the rights, we will win this battle. Because we can talk and make all the noise. This thing doesn't eat the noise, the stomach. We must produce. Thank you.
Oh, sabonga bamtombeni bamakakul. You've said your parting shot was a mouthful. You cannot owe your stomach. Sifuna kudla manje. Whether food is there or not, it doesn't care. Well, honorable members, it's now our turn to actually make comments, ask questions, or make declarations. Yeah. Well, I will recognize hands. And I promise you I'm going to be mean about time because of the problem. Then I recognize the hand of Nyambose. Okay, I will go up. Honorable Matthias. Honorable Klitama. Honorable Dr. Posov. Honorable Mkhacha. And Honorable Adams. And Dr. Matlase.
Thanks, Chair. And thanks to all the presenters in their presentation. Very touching, especially Ngubane with the audio-visual images that we saw. I thought Agri-SA is no longer gonna come and present after that audio-visual because no one needs to explain to any white person what they did in dispossessing black people. Even if they have established commercial farms or established schools or any establishment they have done, that video is telling a white person who is unsuspecting to say you dispossessed people when they owned the land. Today we are labeled with a belittling label of being a labor tenant. You are telling a person who once owned the land through their forebears. Today, it is a white man who's a landowner. Blacks are now tenants. And this is entrenched even in the governmental systems and the language and the labeling. When you say landlords, it's no longer blacks, it's whites. That's a correction we must make. 2, may I say, when I saw the minutes of the Native Affairs Department in 1960, the title of the minutes said, this is the right time to take the land of the Mtetwas in Paul Petersburg to give it over to other tribes. I saw those records with my own eyes and I was in pain. And you know, when did they take them? During the death of Inkosi Mandla Mtetwa in 1960. They said, Mtetwas will be in mourning the whole year. So take their land now. The culture does not allow them to interfere with other people, at least while they are mourning. It will be after mourning that they will come. By the time they come, their land will be gone. This is the practice of Roman, Dutch, and British law, the white man's law that is being used to now return our land. We must now go through the eye of a needle to conform to Roman, Dutch, and British law when our land was never packaged by Romans and by the Dutch and by the British. That's an error. So when land is being returned, you are not doing us a favor, neither government nor white people. You took our land. You are just returning stolen property. And that must be clear. So I don't need to account to anyone. What am I doing with that land? It is my inheritance through my forebears. The same way the farmers are claiming ownership of the farms they're sitting on. They say, here is made you the fatherland. But a black person cannot say the same thing. To say, this is my father's land. And I must explain to a white person. And I must go to court to explain myself. And yet, when a white man says, this is my father's land, it's understandable. When a black man says, this is my forebears' land, it's not understandable because the law we are using is very wrong. Let me go and say, I'm noting Alzu. I know Alzu is a big business in Mpumalanga. Even some of the toll gates, you'll see Alzu, eggs, Alzu. So it is a deliberate intention to take money to give to an established business under pretense that they will manage that money properly to then give black people an empowerment. The opposite is true. They're chowing the money, they're chasing out the people, and there's no accountability. I will follow that up. I know those guys. And they are both in mining, they're in Mpumalanga. So I'm picking that one up. Let me say the same applies with Optima Mine, that I also know. Agri-SA, you are saying you are a legal body. You are not a legal body. You're using the law to defend commercial farmers who are sitting on a land that was taken through Forced Removal Act. And I know the following stakeholders who benefited, and you are one of them as Agri-SA, because you fall under the bracket of commercial industries. And then you are part of the British, you are part of the apartheid regime, the democratic dispensation, the mining houses, property association, service delivery council, Sunrun, commercial industry. These people made money when blacks were removed, especially Amakos in 1913. The beneficiaries to that process, it was yourselves. And now you're using the law to defend against anyone who touches anything that is making profit for you. And you not classify yourself as commercial farmers, as if you are doing farming for us, whereas you're doing farming for yourselves and you're giving even to the abroad countries. During the Ukraine-Russia war, we saw farmers in South Africa complaining of the ship that are sending food to Europe, which are now stuck. As a result, they needed government intervention. Using the farms here, and you are obstructing the land return process because you are doing business abroad and you are gaining foreign currency. We know who are these people. And it is the same farmers who are your members who are ill-treating these people. That's why I was questioning, what's the role of Agri-SA? Are they going to take accountability for the ills that are done by individual members of Agri-SA? Agri-SA are the culprits in this case. But be that as it may, I am saying here, we are going to put it straight to you. The problem here are the white people because of profits. They control the South African economy. They are saying it in our faces that we are in control of the South African economy. It doesn't matter who is in control as government. And as a result, so they pride themselves to say we are in control. We even control government. As a result, we're saying we, the black people, are going to stand up and mobilize ourselves and take our land. We've got evidence to that effect. So even those who claim to be commercial businesses, we know you are there as a result of this. And we even did a mistake in law. The Constitution, in chapter 12, it doesn't return the jurisdiction of Amako.
I was just wondering if you couldn't just narrow it down to the specific presentation, because we are really now
Okay.
at 3:30, but 4 o'clock we must actually leave here.
I'm saying we have made an error in the same constitution that we law to be internationally acclaimed. Chapter 12 is wrong. It doesn't give Amakosi their jurisdiction. Chapter 7 is wrong. It gives the jurisdiction of Amakosi to local government. Local government received that jurisdiction through Forced Removal Act. And we call this perfect, elegant, legal process and constitutional. We are wrong. On those bases, tomorrow I'll lay it out clearly during my presentation what we're gonna do. But we'll expose the fault lines done by the force-filled Roman, Dutch, and British law. Thank you.
Thank you, Honorable Nyambose. Can I then call upon Honorable Matiase to make representation and appeal colleagues to all of you to please be on the point and yeah, thank you.
Honourable Chair, on the 16th of May 2023, we are in this hall. The D is on. The DTG, Honourable Mr. Ndove, raised several points which he repeat those again today. He repeated those points again today. On that specific day, we were looking at the same matter of the Labour Tenants and the role of the Special Master. Among the things that he said is that he did not know of any issues warranting serious concern between the department relationship with the Office of the Special Master, saying that he's not aware of any issues warranting serious concern. But it would seem that there are matters that warrant serious concern. The Special Master got appointed by the court judgment, Moelase court judgment in 2019. And his office got appointed in 2020. And in 2023, 3 years later, on the 16th of May, we had a meeting to reflect on the challenges of this nature. Would he still say today that he's not aware of any issues warranting serious concern? And why so much of the claims have not been settled? I'm raising this not for him to reply to this. And the same will also apply to Mr. Zulu, who in the same meeting said that the department, and I quote him in verbatim, that the department had finalized the fit-for-purpose structure to try and close the gaps identified, including the capacity required to implement the Labour Tenants program. That was in 2023. It's 2025 this year. Fit-for-purpose structure, which he says the department had finalized. But it would seem that nothing has really been done. Perhaps things have gone from bad to worse with the decline or the deduction or reduction of budget allocation to the department to deal with these matters. And that's why earlier I expressed very emotively my disappointment in the department, and there's nothing personal about all what I said, Mr. Ndove and Mr. Zulu. But it can't be business as usual. We've got to get these claims settled once and for all. If we struggle to settle these claims, what guarantees are there that once the minister's proposed bill on land equity or whatever title that bill will have, what are the chances of ensuring that that bill objectives will be realized when we are unable to settle these few claims? And I'm asking these questions with no hope to get any answer from the department, and there's nothing personal about this. I propose, Honourable Chair, as I said earlier, The stakeholders that are here, except for Agri-SA, are not going to get anything from Agri-SA. That's going to take us forward. Because these guys are the custodian of the private property rights, and they want these rights to be entrenched. Other stakeholders must concretely make proposals and to say what is it that needs to be done to resolve these matters. The court has already said that measures must be put in place to resolve these matters. The stakeholders must propose right to us. Lastly, Honorable Chair, there's a case in Free State. It's a horrible case, and I don't want to mention it, of a guy called Mahakwe. He's a friend of Mkrita. In 1988-99, Mahakwe, in a place called Frikierdevlei, was a farm laborer. Out of a labor dispute between him and the farmer, went to murder and slaughter the entire family. Some of the family members escaped and survived. Mahakwe appeared in court, sentenced to life. Under cross-examination, he's been asked, why did you do such a gruesome thing? He says, my intention was to eliminate apartheid. You caught me halfway in my mission to get rid of apartheid by killing these people. You find me having just dealt with the arm. You have just found me halfway when I was busy. At the point at which I was arrested by the police, I was just busy with the arm. I was about to deal with the entire body. Do you want a repeat of this, Honorable Boshoff? And it's only if there's a repeat
please
of
address the chair, not Honorable Boshoff.
It's only if the repeat of this thing repeats itself that there shall be some sense that we have to resolve the land question amicably. And I said it in Afrikaans in the discussions we had yesterday, budget vote, in Afrikaans, so that the message gets home. We don't want anything of that nature of Mahakwe. We want a peaceful resolution and settlement on all these issues in totality. And this is the plea we're making. And this is the outcries we've had from the stakeholders, from different organizations. We need these matters to be resolved as speedily as possible. Thanks, Honorable Chair.
Thank you, Honorable Matthias. Honorable Mkletamo.
Thank you, Chair. Let me start by thanking the representative of AFRA, Ubabu Chobe. You know, the work that AFRA does to defend the rights of farm dwellers is unprecedented. And in many ways, the Mvelase court case shows that path-breaking way in which AFRA is thinking through these issues and finding creative ways to solve the problem it did not create. I'm going to propose that the Progressive Caucus consider writing to the President to ask that he recognizes the AFRA's intervention, particularly on the Mvelase case, for one of the orders that the President gives to people who have achieved certain good works, because I think AFRA deserves it from his historical work, but also now. With this court case, Labour tenants have some possibility to get justice. Since 1996, there was no way. Now we have a special master looking after their interests, and their issues is on the table as a consequence of the work that AFRA has done. So I do think we need, as a nation, to recognize that work and to elevate their contributions so that they continue to do this amazing work. Mr. Setu and Mr. Mokoena, I agree with all the challenges that you have mentioned, and I think a clear proposal from your intervention must be the need for historical and political economy education for government workers, particularly those who are working with farm dwellers and the land question and restitution. You can't have somebody coming from vets without having studied under Professor Levine to come there and be a government official. That's why they say to you, why don't you go to the township when you come there and claim your rights for farm worker, farm dweller rights? Because they have no consciousness of how these things work. And so it is easy for them to dismiss your historical rights because they have no appreciation of the historical circumstances that put you in that situation and why land is so important. You have uneducated people coming out of university, and you can't just give them a responsibility. You need to retrain them, re-educate them, so that they have a good understanding of what this country is coming from and where. Because they come with this white mentality. They reason like agri-SA. No, go to an agri-village. No, we want our land where our people are buried. So this is a proposal that I think we must take forward to even the government and see how it must become compulsory that anyone who touches the land question has some sense of the historical circumstances that we come from. Otherwise, we're going to sit with DA thinking officials who are going to just assist the evictions of our people. Also, I agree that, Chair, I want to propose that we have a monthly update on ALZU. Because it is one of the typical cases of where I think it is through the farm equity schemes where money is just being given to white farmers. Government gives you a big amount of money to buy into the farm, but you remain a farm worker. In fact, most of these people are being evicted. So, Chair, we need to locate properly where these farm equity schemes are in government, because apparently it might be not even the Department of Agriculture that is responsible for this, but it affects farm workers, and that's our constituency. So whoever is responsible for the farm equity schemes, we need to get into a room with them and to take through this matter so that we can defend the rights of our people better. Babu Mngobi, thanks for the film. It is a good tool for oversight, because in one sitting we are able to visit many farms, many situations of labor tenancy, and it brings it out in the most comprehensive fashion. So I do suggest that we find a way to complete viewing that documentary, because it will help. Agri-SA, look here. We're not going to forget about history and move forward. We are here because of history. And you have no moral right to say anything to government. What have you done to contribute towards resolution of these questions, particularly the land question? Agri-SA, you are sitting on land which you have no moral right to have. It is stolen property. Now you come here, you want to educate us about, preach to us about how government, it is not doing its work, and you're making some proposals. No, the proposal must be, what are you doing to return the land which you hold, which you know does not belong to you? What are you doing about that? That's all we want to hear from you. I mean, Professor Levine tells us about ethnic cleansing. 2 million farm dwellers have been evicted from farms by Agri-SA people. Most of our outskirts today are populated by people who were evicted from farms. They have not asked for forgiveness. They have not recognized even the original land theft. They are not saying anything about the contemporary violations, including their members feeding our people to pigs after murdering them. No, we are not going to accept that. Afasa brothers, we hear you and we are with you. And your proposal around double dipping must be seriously considered. You can't have one group of people getting 2 subsidies while others are not getting anything. But that is also not the problem of farmers. It is a problem of government which is not coordinated properly. The one hand does not see what the other hand is doing. So we need a better coordination of these things. I thank you, Chair.
Thank you, Honorable Mkhitam. Honorable Dr. Posov.
Thank you, Honorable Chair. It's always difficult to speak after Honorable Mkhitam, and not because one doesn't want to answer, it's because, you know, it's like Solomon with his wives, you know what to do, you just don't know where to start.
Just return the land, man.
Now, I think that we have a basic problem, and I tried to put that in yesterday's budget response, to say that in 1994 there was an attempt at not dealing with the land question in a political way, but in a legalistic way. And it basically tried to dodge the whole land question. And the reason for that was that there was a low-intensity civil war starting whenever you would like to have it started, I would say since 1976, when white minority rule was seriously challenged in South Africa, and this low-intensity civil war never subsided before 1994. But it did not end with a clear winner and a clear loser. It ended with 2 groups coming to the table and parking some stuff that they didn't know how to solve. And the land question was one of those. And they said basically, like Jan Smith said 50 years earlier or 60 years earlier, I leave this question to a more able following generation. That's what happened. And the problem is that we are still dealing with that. Now, to have the historical narrative on a one-sided way never works. It doesn't lead to a solution. And to say to an organization like Agri-SA, you have nothing to say, it means around here we are talking, we are not listening. One needs to be able to see the reality from the other side. And if I can speak from many farmers' side, of whom I know many, I come from a rural area. White farmers have a way to sell their land more often. They are farmers, but not specifically, let's say, for 10 generations on the same land. And you could say basically every white farmer, or his father or his grandfather, paid for the land. Now, I understand the argument lying beyond this, but this is why we are talking right across one another without meeting, like 2 ships in the dark. Because a white farmer would say, don't call me a thief, I didn't steal this land, I paid and I worked my ass off to pay it. I had a bond with a land bank or with a commercial bank, and I had to pay it. I didn't steal anything. Now, I think several speakers are correct who said the problem lies in the 18th century or in the 19th century. The reason that what I'm trying to say is that's a reason why we are talking across one another without meeting. And we need a political solution for this. We are not going to get a legal solution, a silver bullet which solves everything. I often ask myself, why do white farmers go to Zambia or to Mozambique or to Congo so easily? they get a lease for the land for 30 years or for 50 years. It's because everybody knows exactly who's the boss. It's Mozambique. It's not the farmer. He goes there with a charter to farm this land for 30 or for 50 years. He works out if he's going to make a profit in that time. If he thinks he's going to do it, he does it. And he knows his boss. Who's boss? It's not him. In South Africa, we haven't dealt with the question, if I could say, who's the boss. And I must say, Honourable, I think Mtetwa mentioned a second fatherland. Afrikaners don't have a second fatherland. We have only one. And we need a political solution which recognizes us here in a way in which we are not going to be dissolved like a little bottle of ink in the Gharib Dam. But because that is what our numbers dictate in a unitary state. And that is a difference between the Freedom Front and the DA. The DA believes that if we have a unitary state where everyone just has objective rights, then we come to the place where Honourable Mtetwa always says, you think Roman Dutch law is objective. It is not. It is the mechanism of control of the Western society. To us, and I don't include myself, but I would say 80% of white people, the Roman Dutch law is just the objective law. It's just right. They haven't thought as far as thinking of that as a specific cultural product which African people find oppressing. That's why I asked my party to put me in this room, because I believe I have the capacity to see this thing from both sides, but I can't relinquish my own identity by seeing it from the other side. I remain an Afrikaner, I remain of Africa, and Honourable Matthias is right. We need to get a way in which we don't have to fight this thing till the last drop of blood. Thank you.
Honourable
Just one more thing. Sorry, sir. Chair, the guys of Mankweng who fed those people to the pigs, I can promise you they were not members of Agri SA.
Okay, thank you. Mr. Mkhaga. Okay, can there be no conversation?
That we're dealing with a very emotive issue. Good morning, honourable members and every stakeholder, leadership in the House. Let's welcome the presentations. I will confine myself to those presentations that I've heard. Yes, I'll try. I won't enter this challenge of Honourable Bishop. Honourable Bishop challenged us even yesterday. He is consistent. And I think that Indaba suggested by the department must come easily, because it's clear that in perspectives we differ fundamentally. Until we clarify that point politically, we'll see program, but let alone historical evolution of the land question. Just political, because what the generation of today, we're supposed to be finding each other on many issues in one country, defined by one constitution, citizenship. So let's honourable members maybe allow Honourable Bishop to come up with his perspective. He said he volunteered to represent his philosophy to this body. Chair, Cecil John Rose did a lot of damage in 1894, a precursor to the Land Act of 1913. And I do feel that there are some white colleagues who are still fundamentally defending his statement that he presented in the then apartheid Cape Parliament. And they're serious. And this is a matter that I say maybe we need to engage on. But let me focus to what I regard is the original sin, so that I'm able to differentiate between original owners of the land and the current pseudo-owners of the land. We must be able to differentiate them. So that the question of the original sin as part of a national question is a matter for a resolution. And I thought we have moved to a certain extent in terms of coming closer slowly in addressing this particular question. The first issue is the question of the government support budgets. Al Zoo Farm, an investment of 115 million was done. Then no one is accounting or accountable to such. That investment surely has accrued profits and an interest. It must be money, but who controls this money? Where is this money, in fact? And in that context, if it's also farm that was a contributed investment for black empowerment, all farms and all our people in the same situation across the country qualified for this arrangement or scheme. And surely it's a matter that the department must be able to explain to us how many farms benefited from the scheme and where is the money now that was invested in these different farms across the country. Or call for a forensic audit of all this government support funding that was done as under the pretext of black empowerment in these farms. We hear this thing at a distance, but we know that that's why one day I asked the question about that directly to the department officials, but are you corrupt? You remember that day? Direct question to yourselves, are you corrupt? And you all distance yourself. No, we're not. But now, because we're speaking now to the actual shop stewards on the ground, they are telling us that there are things that are happening that you never informed us as a portfolio committee. So either you are hiding those matters or you thought you will never pick up those issues. And this meeting becomes important, therefore, in that context. The departmental role to protect the rights of tenants must talk to our own department. What becomes your right to protect the rights of tenants? It will be difficult to give responsibilities to a person whom you understand that even the very rights are shaking. Now, what then becomes the departmental role to protect the rights of the tenants? Why these things are happening? Why are you shop stewards of eviction? Why are we evicting our people? Because presenters were clear here to say, you're quick to jump to remove families from these farms without necessarily intervening in behalf of government, to echo the policy of government, protecting our people against eviction. That's the policy on that one. But why are you then decide to be the shop stewards of landowners to evict our people from their motherland? Now, maybe I think this one is it's a worrying factor because you are on the ground, you are representing this government, and if you continue to do these things every day, I'm suppose there's a lot of damage that you've done to our people. It's the question of eviction. Agri-SA, what is your attitude on evictions? What is your attitude? Because I thought you were going to talk to it. What is your attitude on evictions? Because you're not talking history here. We're talking something that happened yesterday. People are being evicted now. It's not a question of politics. It's a reality. Our people are being evicted now by farm owners. What is your attitude to that? the question of policy on RDP houses. Maybe government department must tell us, the top officials, what exactly is the policy of government as far as RDP houses in farms. I'm raising this because I see RDP houses in some of the farms. In my province, for instance, built inside the farms, RDP houses, small location. But what exactly, so that it's not a matter that is discretionary. That's why I'm asking the police, what is the policy of government as far as this matter is concerned? RDP houses and farms. In Kambule family, I suspect that the last, what is the thing that was shown there, was this Kambule family that we visited. Is it this one? That Kambule family that we visited that family last year in Mpumalanga. We visited that family. We were shown all sorts of threats by the farm owners of that area. In fact, that guy mobilized other farm owners whilst we were there as a portfolio committee. That Kambule guy stood his ground. They banned his cars. The farmers banned his car. Now, I think Professor Levin was part of the team when we visited. We saw things here with them. But the right to bury your relatives is one that is touching. What then becomes the attitude of Agri-SA as far as that is concerned? I take Agri-SA, that is an umbrella board. That is non-political. That's what Mr. Rabi declared here. As non-political, and therefore is able to enter any phase. What then becomes your attitude as far as that is concerned? That some families born in this country are unable to bury their relatives, even to see the graves of their forefathers. What then becomes the attitude of Agri-SA as far as that is concerned? And also the AFASA, the African one. Well, the African one must not deal with soft issues, must deal with fundamental questions when it comes to land question. I see and I recognize the interventions, but it must not be an interventionist body. It must be a body that leads in resolution of the problem. And then this is the part, this is what I want to emphasize here. Otherwise, Chair, if things are unfolding in this way, we see things now these days, particularly in KwaZulu-Natal, just people killed at random by farmers, with no reason, no apparent reason, they're just killed. Now, I'm sure the information we got today has empowered us, and I suppose we'll be able to deal with this particular question. Because my worry is what this generation and the passing generation, the next generation is not going to tolerate this. And there are signs that this country might deteriorate into something we never expected. Because there's no way that the black majority in this country would remain as pariahs in their own land. It can't be. It's not natural. It's not done. In other revolutions, farm owners volunteered to assist in resolution of a problem. And there was nothing. People just volunteered. You can go and read the history as a China. You go and read the history as a Cuba. Spanish volunteered with their own farms to assist the struggles. Some farmers. Now, why can't we get these good men and women from our farm owners to say, out of these 16 farms that I'm owning, I'm prepared to hand over 10 farms to government so that the people of South Africa may share on the wealth that they've fought for. There are farmers here. This is question of game farming as a counter to a question of land redistribution. It's a matter that I thought government must develop a law around that particular issue. It can't be that when you know that you can't afford to plow your land, you decide to go to take a shortcut, you collect 10 springboks, and you say this is a game farming. And no one must touch this land because I've registered it as a game farm. It's my farm. That's what is happening all over the country today. Countering the policy of government that says any unused land, government has reserved the right to take over that land. And today, every farmer, even a foreign farmer, just collect few springbok, one lion, this and that, that's game farming. And you can't touch that land because there's an owner here. You can't.
Thank you, Honorable Mkhaka. Honorable Adams.
Thank you, Chairperson.
And honorable members, we might actually miss our buses. We must be very careful on that. Now you have the floor, Madam.
Thank you, Chairperson. I will start with AFRA. And my first question is, what are some of AFRA's core activities? What geographic area does AFRA focus on? And again, on AFRA's work, how does AFRA address evictions and tenure security? What role does AFRA play in land reform? And how does AFRA ensure its work is impactful? And about AFRA's impact, how does AFRA contribute to food security? How does AFRA address poverty reduction? And how does AFRA address gender equality in land access? And on the related to land reform challenges, how does AFRA address the issues of budget cuts to land reform? And what is AFRA's perspective on the current land policies? And what role does AFRA see itself playing in achieving this vision? And to Agri-SA presentation, on the background, AFRA stated there that after the SMLT was appointed, the question is, was there any feedback on the adjustment to oversee the claim resolution? And on progress by SMLT to date, there was 3 points that was raised. My question there is, how do you become across these above mentioned? Do you have any communication or any evidence on the matter? And on the matter of policy and legislature impediments, on what basis are you referring to the 7 points stated in your presentation? And then AFSA, what is AFSA's assessment of the current state of agriculture production in South Africa? And what are the key challenges faced by its members? How is AFSA involved in the implementation of the government's land reform program? And what measures are being taken to ensure equitable access to land for all farmers? My last one, Chair, what steps is AFSA taking to ensure that its members comply with relevant environmental regulations and safety standards? I thank you.
Thank you, Honorable Adams. Honorable members, Dr. Matlase.
Okay, thank you, Chairperson. I will definitely be short because my colleagues have covered me. I think the whole thing is wrong. It doesn't matter how we looked at it, because the mere fact that we are sitting here and call our people tenants, it makes the whole conversation wrong. because we believe that we are the owners of the land. And that is why we will come up with these Molanyana Acts or bills to cover up for the original sin. But my question will be based on the contribution from Agri-SA. My question then is, the Agri-SA has recommended the establishment of a well-resourced unit within the department, supported by a clear and accountable governance structure to focus on Labour Tenants matters. What specific function will such a unit be expected to fulfill, and where it should be located, in the department or outside the department? My second question, what functions will this proposed unit undertake, and what funding model or financial framework will be appreciated to ensure sustainability and its effectiveness? Then my last question will be, currently, as Agri-SA, currently, what mechanism that Agri-SA holds its members accountable when they infringe the rights of Labour tenants and farm dwellers? One will also remember Agri-SA was established in 1904. That means when 1913 happened, Agri-SA was already established. So it's very important when we answer these questions, we also think of how much we have contributed for making billions in South Africa. Chairperson, I submit.
Thank you, Dr. Matlase. I will hand over to the acting DG. I know that he is also equally pressed for time because he has an appointment at 4 o'clock. But I will plead with his team, including the members of the civil society, to please respond to those questions that were specifically directed to them in writing, and submit those answers within the next 2 weeks. In the same way as we have said, with regard to some of the questions that were directed to the department, so that we have a holistic and comprehensive consideration of all the responses that would have come from the various stakeholders. DG, Director General.
So thank you, Chairperson, and thank you, honourable members, and to all the stakeholders. It was good to meet you all today. Chair, I think, firstly, let me just reaffirm the department's commitment to resolving some of these issues, to working with the partners and with the Special Master. We concur that I think we've got over 150 questions from the session today. We'll answer those. It's been a long day, and I think it was a worthwhile day for us to just get back to the basics of what needs to be done. I do believe that working with the Special Master and all the role players, that we can come to a solution that speeds up this process. I think that we are here definitely to defend the poor, to make sure we execute on delivery. We are going to look at the workshop that we're going to have with the Special Master under his guidance, and that was also agreed by the Minister this morning in the meeting. We're also going to look at quarterly coordination meetings with the Special Master and the Minister. That was agreed upon. And I'm sure that the representation in the room will come through the Special Master, and we will also facilitate that. Then the strategic litigation workshop that was agreed on by the Minister, I confirm my availability to formally open the forthcoming strategic litigation workshop. And this workshop will be critical platform for our legal strategies with constitutional imperatives that ensure litigation supports meaningful resolution at the end of the day. Then resource mobilization and support, I think we've agreed that there's already funding towards the Commission. Whether that funding is sufficient, based on the speeding up of the process, we will discuss with the I'll say Commission, the Special Master, and then also I think I've already given. We will start immediately looking at the release of the digital platform that the Commission has raised, so that we can start implementing that as soon as possible, so that we can get a good understanding what the layout of the Labour Tenants looks like nationally, for better decision making. So, yeah, Chair, I think I'm going to, if I keep on going, I'll be the responsible for missing buses. So thank you, Chair.
Well, thanks, Honourable Acting DG. But I feel that perhaps it would be a bit of injustice for some of our guests here not to be given an opportunity to, even though they would not be substantially responding to questions, but to have an overview of what has actually transpired here. For instance, I would like to start off with Afasa. I know there were questions directed to Afasa. I would give them 1.5 minutes to actually say something.
Okay, thank you, Chairperson. In our opening statement, we said, well, we are not directly dealing with the Labour tenants, but we are dealing with our farmers. But some of those Labour tenants, they are now currently farmers. So we would like to come back. We'll write a letter to you, Chairperson. We'll request a meeting to talk our agenda. One of the honourable member here was saying, what are we doing in terms of policy, influencing the policy? Today we couldn't say much on behalf of our black farmers in the country and what is the agenda of a land distribution. There are big things that are happening, but we will ask maybe in future to be given a chance to come and present. And that would happen as soon as possible. And we believe that you will respond to our letters, because we wrote so many letters from last year to the office of the minister, but there is no response. Thank you. Even an acknowledgement.
Well, thank you, Afasa. I hope you do understand the differentiation. We are not part of the department. We are part of Parliament. So your letters were directed to the department. So we don't know what happened there. But nonetheless, they are here. They hear for themselves that they actually don't respond to correspondences, which is not good enough. Then Afra. And to say that we will actually welcome your submission, your document.
No, we understand very well, yes, Chairperson, that this is a political portfolio committee with different political parties and our official. We understand it very well.
No, thank you.
And we are so happy and grateful to be part of this session. Thank you.
Okay, thank you. I was actually referring to the promise that you have just made in relation to the document that you say you are going to actually, you would like to present to us. We will try to find time to invite you to come again and make a substantive presentation. Thank you. Afra?
Ngiyabonga kakhulu, Honourable Chairperson. Yeah, I confirm that the list of questions, I think I've got about 8 questions that were asked by the Honourable Member that we will respond in writing. But generally, I think the important thing is to share that as Afra, we are, one of our biggest programs is around impact litigation. So the cases that we lead have national impact in that, for example, the case we're dealing with here, which was obviously decided on by the Constitutional Court, making it therefore binding nationally. So we are based in KZN geographically, but our work through litigation and partnering with other like-minded organizations, we do have a national footprint in that way. It's also important to stress that, You know, one of my former colleagues who ended up being the Director General in this department, Mr. Mtu Shabane, made a joke years ago at AFRA, when he was working at AFRA, where he said, you can't eat tenure. And that ended up influencing our programs in that we don't now end in promoting or protecting rights. We do work now around post-settlement support, and even for those people who still live on land they do not own, we now have a food systems program where we advance agroecology as a model for farming. So we do support, we do source funding to directly support beneficiaries with inputs, mentoring and the like, and we also link them to government for support. So that is our contribution in terms of poverty reduction and food security. Just a short point on the important part of gender equality. One of the community-based organizations that we support is Qina Mbokodo, which is an organized women's network, women from farms who have created an organization which we assisted or facilitate their establishment, and we continue to raise funding to support them so that they can carry out their activities. And we ensure that they are in decision-making spaces to ensure the enhancement of women's voices and highlighting the issues of women and girls on farms. That's just one. But I will answer in writing in terms of more detailed response. I think on behalf of AFRA, I'd like to thank this committee and through you, Honorable Chairperson, for inviting us to this platform. And as I echo the acting DG's sentiments in that it was a worthwhile a day. I think my parting shot would be to request that department to do what they have never done, which is to embrace the Constitutional Court's decision and accept that it's law. Nothing will happen if we have this continued ignoring of this court order. I think I would like the leadership through you, acting DG, to just ensure it filters down to every single official that the special master is not the enemy, the people that are poor on farms are not the enemy. The work that has to be done is to advance the lives of people. And many honorable members have mentioned that these terms that we use, when I enter farms and I call a meeting of Labour Tenants, people don't even know that they are Labour Tenants. They never coined themselves Labour Tenants. So these phrases that we use, again, that's why it's important to go out to people and educate people. But we need to change the mindset of officials so that they don't deal with people as just something that's part of law. It's human beings. And so I would really request that the department from top filters down a new spirit of embracing the Constitutional Court judgment and embracing the special master as a partner. And we also offer ourselves to the department with all our network on the ground with community-based organizations and land activists that we work with and other sister organizations that are out there. We offer ourselves to put our proverbial shoulder to the wheel and assist to ensure the upliftment of people on farms. Thank you very much, Chairperson.
Thank you, Afra. Agri-SA.
Chair, thank you for the opportunity. It was obviously not an easy day for Agri-SA in this portfolio committee. However, we remain available to engage at all times. This body is here in part to assist in creating laws. Our position remains the same. We are there to ensure that the laws are properly applied and interpreted in South Africa and upheld. That is the essence of what Agri-SA stands for on behalf of our affiliated members, Chair, and I'll leave it at that. Thank you.
Thank you, Agri-SA. Well, I know that one of my colleagues actually said that he was not going to listen to Agri-SA. I want to say that we invited Agri-SA because they are a stakeholder. We may or may not like them, but they are there. We invited them. We are still going to invite them because this issue of land is very complex. And I would also apologize to some of the people who might have felt that there were some too hard words that were actually uttered. it's because the issue that we are actually handling is very emotive and is very complex. I was part of the CODESA process myself from 1992 until 1994. So I did actually take part in a theme committee that attempted to deal with this matter. And it was shelved because immediately you touch the issue of land, feathers would just fly. Then we parked this matter with the hope that at some future time, we will find time to actually deal with it. And I'm hoping that the much talked about, national dialogue would actually be an ideal platform to deal with this matter. And also, colleagues, it is also always important to contextualize this discussion because the basis of our constitution is what is that document which actually was produced in 1955?
We reject the Freedom Charter.
The Freedom Charter. Okay, that's a debate for another time. But it is there. It was actually used as a cornerstone for our constitutional development. And so we must actually be mindful of that. And also our constitution as well. So I just wanted to allay the anxieties that may have existed in the mind of the Agri-SA delegate. Can I actually then ask Professor Levine to have his say?
Thank you very much, Chairperson, and to the honourable members, to the colleagues, to those that I work with in civil society. I appreciate the meeting. It's true, as the acting DG said, that the Minister did meet with me this morning prior to this meeting, and we made a number of commitments that I'll need to brief my colleagues from the department on, including the fact that we are going to be reporting to him jointly on a regular basis on the progress of the program. So I feel that I've had time well spent here today because we do have commitments all around for us to really try and make the program move. We believe we've developed the tools. Obviously, when you try and do things in different ways, you modify and change them as you go along. But we think if we apply the tools as we've developed them, we will be able to speed up the program. We will have accurate and reliable data, and we will be able to bring just and equitable solutions to Labour tenants on the ground. And that's what's really fundamental. The evaluation system that we have, or framework that we've drafted now, which will be further consulted with the parties to the court process, that is the Labour tenant applicants, AFRA on the one side and the department on the other side. They will have adequate time to respond to it. But we believe that once we implement the system, it will also provide the kind of forum and engagement platform that will enable us to improve as we go along and to really get this program kicking. So we're always willing to come to the Portfolio Committee. We're very grateful for the support and encouragement we get from this committee. And I understand the frustration of a number of the members that they articulated today on the slow progress. So I think that's really the challenge to ourselves in the department, is to really lift this thing into full gear and move the process decisively forward. Thank you so much, Honourable Chair.
Well, thank you, Prof. Levine. In closing the meeting, I would also like to pose certain questions and comments and requests to the department, and I think that the department should seriously consider the idea of capacity building for its land reform staff, because it would appear that they are actually not fully, conversant with the intricacies that are involved in the legal framework that actually governs the land reform in this country. So it is very, very, very important. And that curriculum should, in my view, include political economy of land reform. So it will address problems where officials actually tell labor tenants to go to townships or forcing restitution claimants to accept cash, for instance, cash compensations in settlement of their land claims. So it is because they don't actually appreciate the value of land, and they don't know they need to be educated on that. And secondly, the department must submit the following reports. The Alzu farms, what has actually happened on that farm, including the funding and the joint venture arrangements, as well as shareholdings in the Alzu farm. The Free State farm, where the officials are said to be actually evicting black farms or farmers or their families or spouses. We need to actually have some information on what actually is happening there. AFRA's inputs demonstrate actually a need for a conversation amongst stakeholders on the settlement of labor tenants applications. So it appears that they are actually not talking to each other. The committee would anticipate a report on the engagements and a clear way forward to speed up delivery of land and improve their socio-economic conditions of labor tenants and farm dwellers. So, Jobe, I would really appreciate that there should be actually regular interface at that level, so that you actually ultimately speak with one voice, or at least have a common vision on where you're actually going. With that, I do want to thank your patience and appreciate that you are also appreciating that we have invited you to come, and I can promise you this committee is pursuing an open door policy because we are the GNU, and therefore we are breathing fresh air on things that hitherto actually did not exist. Well, something was said about the Progressive Caucus meeting somewhere. Then I need to say something about the GNU. Well, on that note, honorable members and acting DG and your team, the meeting is actually adjourned. Thank you so much.